Yes, please.
Can I have a motion tomorrow, my lord? I filed yesterday, my lord. Tomorrow.
Why tomorrow?
But some urgency is there, my lord, because a post is going to be filled up, my lord. Because I am working in that post for the last 22 years, my lord. I have already filed, my lord.
We'll
Tomorrow,
have it on Friday.
my lord, then day after tomorrow, my lord. I am obliged.
Wait, please. Lordship, I beg to mention for listing of a motion, my lord, method, not for admission hearing. On any date after vacation, my lord, on a hearing date preferably, my lord.
What is it?
For admission hearing, petitioner was terminated from service pursuant to a departmental procedure. After vacation, any date subject to your lordship convenience, my lord, on a hearing date.
27th. 27th
July. Right.
My pleasure. My lord, I filed an IA in the month of February, 27th February, for implement of party in a contempt case. It has not been listed. My lord,
Friday.
well, obliged.
May I please, your lordship? With regard to item number 5, my lord, we have filed our affidavit in reply yesterday, my lord. That may be called on record, my lord.
May I please, your lordship? Okay, I beg to mention for listing an IA for orders, lordship, on Friday.
Monday.
Obliged.
May I please, my lord? In item number 17, I have filed one affidavit in reply yesterday. I may be allowed to call that affidavit, my lord. Obliged.
May I please, your lordship? My lord, I beg to answer a writ petition for listing, my lord. My lord, the matter pertains to provincialization of service matter, my lord. It was lastly posted on 26/09/2022.
23rd.
And another similar matter, my lord, provincialization of service, my lord. It was lastly posted on 27/01/2023.
That will come after vacation.
Give me any date, my lord.
Yeah. 26th.
May I please, the lordship, my lord, I pray for listing of a matter, my lord, teacher, my lord, he had retired in the year 2019, pension has not been granted, my lord. So any date, my lord, on Monday next, my lord.
uh,
2019, my lord, retired, no.
21st.
20. Obliged, my
His
lord.
lordship, with the consent of the other side, beg to mention item number 15, my lord.
Item.
Item 15, hearing matter, my lord. The matter may come up after vacation.
Quartered matter.
Yes, my lord.
You are paying for?
I'm for agriculture department on behalf of Mr. Arbora.
Have you
I
taken the consent from the?
yes, my lord. I'm for the petitioner, my lord.
On request made on behalf of Mr. N. Bora.
US Bora.
US
On behalf of Miss Arbora.
R. Bora, as a council, then standing council, agriculture department.
Yes, my lord.
This is the matter up to the summer vacation.
After vacation, my lord, if you
That's what I'm saying, up to summer vacation.
obliged. On 18th, my lords, may I have a fixed date, my lords?
You want to fix it?
I'm for the petitioner, my lord. 18 is a Tuesday, my lord. Deeply obliged.
May I please, your lordship? With the consent of the other side, I beg to mention item number 1, my lord.
But in this case, my lordship, can you fix a date, my lord? 28, yeah.
Any mention memo is there?
Today itself, I will file.
Item 1, he wants to mention.
Mail.
Item 1.
Wait for your turn. Wait for your turn.
I beg to mention, my lord, to listing the case, my lord, admission hearing, my lord, matter related to shifting of the school, my lord, due to stay order, my lord, shifting could not be met and students suffering, my lord, any date before vacation, my lord.
22nd.
Obliged.
May I please, your lordship? I beg to mention for a listing of a contempt case. Your lordship, this matter was last posted on 8/2/23.
After vacation.
My please, lordship. I beg to mention for listing of a writ petition for orders, lordship. Before vacation, any date, lordship.
For orders.
Yes, lordship.
23rd.
Much obliged.
May I please, your lordship?
May I please, your lordship? Lordship, I beg to mention this case for listing. We have filed this case yesterday. These were related to restitution of exam of the students of Dibrugarh University. The examination of some of the petitioners will held and some are to be held. So I pitch the matter may be listed tomorrow.
Why tomorrow? Friday.
May I plead your lordship? I wish to mention for listing of a WPC for motion, which was filed on yesterday, lordship.
21st.
Oblige.
May I please the lordship? I am listing for WBC, my lord, filed today. For this matter relating to the teacher transferred to another school, my lord. There is not allowed to join.
21st.
I love it.
I please your lordship. Lordship, with the consent of the other side, I beg to mention item number 20 of daily list for adjournment. As my senior Mr. S.K. Medhi is out of session. Interim or lordship, interim order passed earlier may be continued.
You are appearing on behalf of,
S.K. Medhi, on behalf of the petitioner.
on request made on behalf of Mr. S.K. Mehta, that the council for the petitioner list the matter
After vacation, lordship.
after the summer vacation.
Lordship, interim order may be continued.
Order passed, earlier to continue till the next.
Oblige, lordship.
May I please the lordship? I would like you to mention this matter for listing on admission states. It relates to appointment of regular principal.
After vacation.
Lordship, before vacation, if
You
possible.
want it before vacation. There is no time
Okay,
after vacation.
oblige.
I beg to mention an item for listing. The matter is relating to regular as the service of the petitioner.
After vacation.
May it please your lordship, I beg to pay before listing this contempt matters, lordship, for orders, lordship.
After vacation. Yes, go.
Item 1 of the.
Yes, you wanted an adjournment in this matter.
Yes, my lord,
You are appealing for?
for BK Das.
No response.
আমি petitioner.
On request made on behalf of Mr. B.K. Das, Learned Counsel for the petitioner in WBC 3157 of 2021. Please, the matter after
1 week, my
Next, my lord,
after 1 week.
28. 20.
20 is too much.
No, this is a case of non-payment, my lord, that's why.
26.
Hello.
oblige, ma'am.
Twenty-four of supplementary list. My lord, as per direction of this court, my lord, today we are going to file affidavit in opposition, my lord.
Where is the applicant?
24.
Yes, lordship, I've heard the matter extensively on last occasion. The issue is related to that the selection and approval of the president of school development and management committee. The contention of the writ petitioner is that in violation of the notification dated to
Just now, my lord, just now I have served him copy and we are going to file affidavit, my lord, today.
I'll not
Friday,
file, I'll not file any reply, lordship. It is the same thing that
He has not filed his affidavit.
yes, file.
No, just served him, but I'm. going to-
Sorry, he is yet to file. I thought that he has filed.
Okay, heard absent Malinda, Learned Counsel for the applicant. Mr.
M. Ali.
M. Ali, Learned Counsel for the opposite party number 1.
1 and 2.
1 and 2. Submit that is filing affidavit this morning. So accordingly, is the matter after 1 week,
Lordship, date by 16, it may be taken on 16, Lord.
not 16. 21st.
Highly obliged.
21st. Yes, Lordship, oblige.
2 and 3 of the admission.
May it please your lord.
These two are similar matters, Lordship.
For the time being.
Why?
Mr. PJ Pokon is on another courier. PJ Pokon is standing council got university.
Even after some time, he wants it after some.
If his matter can be heard today, your Lordship, already everything.
4.
May I please, as your lordship? May I please, as your lordship? My lord, in this matter, my lordship has already heard once, and there is a direction for filing of the affidavit, and that affidavit has also been filed, and copy has also been duly served. My lord, the issue in this petition is
What is?
My lord, this case, my lord, respondent number 3 is filed affidavit. We will put time to file reply, my lord.
To what?
Affidavit filed by respondent number 3, my lord.
Affidavit filed by respondent number 3.
My lord.
by the director, my lord, in our petition, my lord. কোনো দিছে?
Yes. You are appearing for?
My lord,
By the private, they are appearing for the private respondent, my lord.
Private, how do you file a reply to this affidavit now?
They are not required, my lord. It is our responsibility.
Oh.
It's a delay, my lord. They don't want the disposal of the case, my lord. Last 2-3 occasions, my lord, this matter came up. We have some urgency, my lord.
Yes. Proceed.
My lord, the issue in this petition, my lord, is that an speaking order is under challenge. My lord may be pleased to find the speaking order, my lord, is at page, my lord, at page 36, my lord. May I read over, my lord?
Who is the original one?
My lord, the original one is in the very next page, my lord, is at page 38, my lord. Should by the District Elementary Education Officer, my lord. The Topogan MEM provincialized on 19/11/1991. The headmaster Majnu Mia, he will be retired on 31/7/2021. He unable to decide to hand over the charge of headmaster to the senior most assistant teacher. That's Badar Ali, senior most Arabic teacher. He is a graduate, untrained teacher and his service provincialized on 19/11/1991. On another senior most Hindi teacher, namely Sri Suranjan Kumar Chanda, is a trained graduate Hindi teacher. His service also provincialized on 19/11/1991. As per the report submitted by the Block Elementary Education Officer Srijan Gram, by later number so-and-so, dated so-and-so. Order. In the above, it is found that Suranjan Kumar Chanda, the trained graduate Hindi teacher, and in pursuance of the report submitted by the Block Elementary Education Officer Srijan Gram, Majnu Mia, headmaster of the Topogan MEM, he is directed to hand over the charge of headmaster to the Topogan MEM to Suranjan Kumar Chanda, trained graduate Hindi teacher at the time of retirement on 31/7/2021 afternoon. Suranjan Kumar Chanda, trained graduate Hindi teacher, is hereby allowed to take over the charges of the headmaster from Majnu Mia, headmaster to be retired on 31/7/2021. Now, my lord, the basic challenge to this petition on the ground that I, being the, my lord, senior most teacher in the institution, my lord, counting the date of seniority from the date of my initial appointment, the charge of headmaster was ought to have given to me. But my lord, as from this order, it reflects that the district elementary education officer treated the private respondent to be qualified, and my lord, the date of seniority has also not been, my lord, calculated, and that apart, my lord, the other issues has also not been considered, and this has been given to this private respondent. Accordingly, my lord, when we challenge this petition, my lord, this speaking order before this honorable court, my lord, the state respondent has come up with the affidavit, as well as the private respondent has also come with an affidavit, and the core contention, my lord, in the case is a report prepared by the, my lord, respondent, and that report, my lord, we have also bring into before this honorable court by of an additional affidavit, my lord. My lord may be pleased to find that report. This is the, my lord, report prepared by the director of elementary. My lord has got the additional affidavit, my lord. That's, my lord, filed by this Badar Ali. My lord may be pleased to turn to page number 73, my lord, the chronology of page, my lord.
73.
73, yes, my lord.
1 minute. 73 is affidavit in opposition.
Yeah, my lord, actually, it should be an additional affidavit, wrongly written as an additional affidavit filed by the petitioner himself, my lord. That's why it should not be affidavit in opposition. It should, the heading is wrong, my lord. It should be an additional affidavit, my lord.
You have filed 2 additional affidavits.
Yes, my lord, yes.
Page number 73 is the affidavit in opposition filed by the responsible.
My lord, this is filed by the, my lord, state, by the Director of Elementary Education, my lord. The page number 73, which I am referring, is a, my lord, affidavit filed by the Director of Elementary Education, my lord.
No,
Suranjan Kumar.
something is wrong.
No, my lord, it is
Page 73, running page.
running page, my lord. Running page 73 is the, my lord, one of the report.
Affidavit in opposition filed by
Response number 3.
Suranjan Kumar Senapati, my lord. Suranjana Senapati, my lord. The Director of Elementary Education.
that is page 76.
Oh, my lord, my friend when served copy to us, my lord, it has been marked as 73, my lord.
Then let us go according to the
Yes, yes. My lord, in this,
1 minute.
my lord.
Additional affidavit you are referring.
My lord, I am referring to an additional affidavit filed by the petitioner, my lord, Badar Ali, and it was filed on, my lord, 31st day of August 2022, my lord.
Yes.
My lord, in this edition, yes,
Boyan, you better correct this now. Otherwise, there'll be some problem.
my lord, I'll do the needful, my lord.
You correct.
No, additional, an additional affidavit হয়েছে না? But I should be correct it as an additional affidavit, my lord.
With your signature.
Yes, yes, my lord. Okay, there is by now. Yeah. My lord. My lord, in this additional affidavit, my lord, I am referring to the Annexure 2 document. Is a, my lord, report prepared by the, my lord, Director of Elementary Education, my lord.
Yes.
My lord, in this report, that everything has been written, my lord, in the, and we are, my lord, in the findings part is relevant. My lord, may be pleased to find it as a page 17. Internal page, my lord. Findings is that, my lord, may I read the findings, my lord?
Yes.
From the statement submitted by the District Elementary Education Officer Bongaigaon and the petitioner, the case and also the records available in the office of the District Elementary Education Officer Assam, it is seen that Badar Ali was appointed prior to Suranjan Kumar Chanda by the School Managing Committee SMC, and Badar Ali was appointed on 7/1/1983. My lord, may kindly note the date, my lord. 7/1/1983, and Suranjan Kumar Chanda was appointed on 12/9/1986. But Badar Ali was underaged when he was appointed by the School Managing Committee. As reported by the District Elementary Education Officer, as revealed by his SSLC certificate to Annexure 5, he was just 16 years, 16 days old when the SMC appointed him. His date of birth as per his service book being 21/1/1967. The District Elementary Education Officer has reported that the Annexure 1 above
the school managing committee therefore regularized his service in 1988. That is after 5 years from his initial appointment by the SMC Annexure 6. As a matter of fact, therefore, Sri Suranjan Kumar Chanda is senior to Sri Badar Ali as much as the services of Sri Badar Ali was regularized by the SMC in 1988. But this is to mention here that although the Badar Ali was junior to Suranjan Kumar Chanda, to consider in his light, yet the name of Badar Ali appeared before the Suranjan Kumar Chanda in the provincialization appointment order dated 13/3/1992 Annexure 8. The headmaster of the venture educational institutions sent proposal for provincialization with the joining details of the working teachers. The government does not have any authority over the schools till they are in the venture stage. The Badar Ali was underage and underqualified when he was first appointed by the school managing committee, did not come to the notice of the authorities when provincializing his service. Likewise, the date of appointment of Badar Ali was entered as 7/1/1983 in his service book 2. Inevitably, therefore, the district gradation list the petitioner Badar Ali has referred to also has placed Badar Ali as senior to the Suranjan Kumar Chanda. But the difficulty in considering the Badar Ali's date of appointment as 7/1/1983 is that he was underage and underqualified at that time. Conclusion. The school, though the school managing committee appointed Badar Ali as Arabic teacher on 7/1/1983, but at that time he was underage and underqualified for the said post. Subsequently, his service was formally regularized. After attaining the required age of appointment, as per the existing government rules, as well as the acquisition of the required qualification during the year 1988 by minutes of the SMC meeting dated so-and-so. Hence, Badar Ali cannot be considered as a teacher until his service was regularized by the SMC in 1988. His service is to be counted only from 34/1988 after attaining the requiring age as well as the qualification. On the other hand, Sri Suranjan Kumar Chanda was appointed by the SMC on so-and-so as Hindi teacher, as he fulfilled all the conditions required for appointment as an assistant teacher for the upper primary school. Analyzing all the above, the committee is of the view that Sri Suranjan Kumar Chanda may be regarded as senior to Badar Ali. Now, my lord, from this report, it transpires, my lord, that the decision which they have taken, that my initial date of appointment, my lord, when I was appointed, was basic contention that cannot be taken into account, that I was underage. Secondly, my lord, they have said that I was underqualified or something like that when I become qualified. But my lord, before the date of regularization by the school managing committee, when the school was in a venture stage, my lord, it was the discretion of the school manager. My lordship is well aware, my lord, that these categories of school, when in a venture stage, the school managing committee or the authority is the appropriate authority to regulate the service condition of these categories of employees, my lord. Accordingly, my lord, the school managing committee, when my lord found that I attained the required age and qualification, my lord, they have regularized my service from counting my initial date of appointment, that is, my lord, 7/1/1983. Once the regularization came, my lord, my initial date of appointment, that is 7/1/1983, is being, my lord, is held to be a valid one. They have not wiped out. Once it is regularized, my lord, the past service from the date of regularization till 1983, that period they cannot wiped out, my lord, and which they have not also wiped out in their minutes also, my lord. Now, for a moment, my lord, I again beg to draw my lordship's kind attention to the provincialization order, my lord, which is available in the original writ petition, my lord. My lord, may kindly turn to page 24 of my writ petition, my lord. This is the typed copy, my lord, and the original one is very, next one is not very legible, my lord. Page 24, Annexure 5. May I read over, my lord? It's a very important document, my lord. In pursuance of the government letter number, so-and-so dated 16/11/1991, in communicated by the DEE Assam by this order memo number, so-and-so dated so-and-so January 1992, the services of the following teaching and non-teaching staff of the ME school, madrasa having the requisite qualification, who were appointed by the managing committee are provisionally regularized and brought under provincialization with effect from 1911-1991 in the scale of pay shown below against the East plus other allowances as admissible under the rule. Now, my lord, may kindly turn to the next page, my lord. Is at page 25, serial number 4, my lord. In serial number 4, this is the petitioner, my lord, may be pleased to find that the arts teacher filed resolution number 2 dated 26/10/1982 is the date of resolution, which had been, my lord, recognized by the government as well as by the Director of Elementary Education Assam, my lord. And this initial date of appointment has been treated as my initial date of entry into the service, and accordingly, my lord, my service was provincialized. Because, my lord, why the government has done this? Because, my lord, the managing committee, while I in a venture stage, my lord, regularized my irregular period. That's why, my lord, the government has also treated my initial date of appointment from the date of, my lord, 1982 till 1988 is a valid one, and therefore the government has also not wiped out my initial date of appointment or the initial entry into the service. Now, my lord, once the government has accorded its approval by way of a letter dated 16/11/1991, in my lord, considered opinion and my respectful submission before my lordship is that now the director, my lord, cannot come up with a report and cannot wipe out this my initial date of appointment and my initial period of service till the time of my regularization, my lord, which the director is not trying to do, which will, my lord, is a one kind of attempt to supersede the approval of the government, my lord, which is not permissible.
Where is the government's approval?
My lord, in the very letter it has been, which I have just brought into my lordship's notice at page 24, my lord. In pursuance of the government letter number dated 16/11/1991, this is a letter, my lord, giving approval for the purpose of provincialization by the government. Then only this letter has generated, my lord, the district elementary education officer, the director of elementary education officer addressed to the district elementary
Where is
education
this
officer.
letter? Where is this letter?
No, my lord, this letter, we do not have the access, my lord. It is had the access of the government, my lord. My lord. So, my lord, therefore, my lordship, on the last occasion when my lord wanted to know that what is the reason for provincializing my, keeping the my initial date of appointment of 1982. To that effect, my lord, there is a direction for filing the affidavit to clarifying this contention that whether, my lord, my initial date of appointment can be counted for the purpose of provincialization, or can the director supersede the approval of the government, my lord. But the affidavit which they have filed recently, my lord, which my respected friend has also just relied on, that is an affidavit, my lord, may be pleased to find.
Director's affidavit.
Yes, yes, my lord, the director's affidavit. Director is here from there. My lord, the director's affidavit filed by the director, my lord, Suranjana Senapati, recently, my lord. My lord, may I, my lord, refer to page 70, paragraph 10, my lord. My lord, got it, my lord, paragraph 10, my lord. That as regards the averment made in paragraph 10 of the writ petition, the deponent states that the Tapoban MEM was provincialized on 19/11/1991, and services of all the teaching and non-teaching staff were provincialized on 19/11/1991. Further, the deponent decided the matter of in charge headmaster of the Topogan MEM as qualifying service of both the teachers are same, and the petitioner as well as the respondent number 6 are graduate teacher, but the petitioner Bodorali graduate untrained Arabic teacher and respondent number 6 Suranjan Kumar Chanda trained graduate teacher. Hence, the deponent decided to allow the respondent number 6 Suranjan Kumar Chanda to function as the in charge headmaster of the Topogan MEM.
1 minute. Where is
My
the
lord.
director's report?
My lord, the director's report, same report they have relied again, my lord. Same report which I have just read over, my lord. This is the same report.
Yes.
So same report, my lord, they have relied on, but in this affidavit, my lord, when I have perused, my lord, I have not found any averment or statement that whether the provincialization, my lord, which has been given to the, and secondly, my lord, in paragraph 11, my lord, may I read over, my lord, that as regards the averment made in paragraph 11 of the writ petition, the deponent states that the petitioner was appointed as an Arabic teacher by the managing committee. But at the time of his initial appointment, the petitioner was underqualified as the petitioner passed the HSLC examination only in the year 1983. It is further stated by the deponent that on 10/6/2022, after hearing parties in the instant proceeding, this honorable court was pleased to direct the answering deponent to make an inquiry by calling for the record of the service particulars of so-and-so madrasa and submit an inquiry report before the court as regards the date of appointment of the writ petitioner. Accordingly, inquiry committee was constituted consisting of the 3 members by the answering deponent. It is further stated by the deponent that on 18/6/2022, the inquiry committee conducted the hearing wherein the petitioner as well as the respondent number 6 were personally present, and the inquiry committee recorded the written statement submitted by the petitioner as well as the respondent number 6. It is stated by the deponent that the district elementary education officer Bongaigaon, who is also the in-charge block elementary education officer, Srijan Gram, has submitted her written statement as one of the member of the inquiry committee. A copy of the inquiry report dated 18/6/2022. Milord, this is the same report, the exactly ditto report, Milord, they have relied on, which I have just brought into my lordship's kind consideration, Milord. So, Milord, the very basic, Milord, contention which we have raised, Milord, in our petition, that whether the benefit of provincialization treating my date of initial appointment as 1982 and the approval of the government treating my date of initial appointment as 1982, can it be wiped out, my lord? I am putting a question to myself, my lord. It cannot be wiped out because, my lord, this has been held to be valid when the school managing committee, my lord, when they have regularized my irregular period, treating my initial date of appointment as 1982. Now, after a gap of more than 40 years, my lord, they cannot reopen the issue. That is the issue, my lord. And secondly, another contention which the director has said, trained teacher. My lord, there is no any such criteria laid down under the rules that a trained teacher is eligible and untrained teacher is not eligible. It is a issue of qualification, my lord. What is the basic qualification is required for the purpose of holding the charge? So, my lord, the trained and untrained teacher is not the issue, my lord, for the purpose of holding. It is the seniority will, my lord, prevail. For the purpose of, my lord, giving or conferring the charge of the headmaster in these categories of school, my lord.
Mr. Bhuyan,
My lord.
in this provincialization order,
My lord.
page 24,
Yes, my lord.
you are shown as 26/10/1982,
Yes, my lord.
but you entered service in 1983, isn't it?
My lord, my lord, this is no, my lord, this is the this is the recognition, resolution date has been recorded, my lord. My lord, my appointment order I have annexed, my lord.
This is a resolution order.
Resolution, the resolution adopted by the managing committee, my lord, that has been recorded in that order, my lord. My lord, may be pleased to verify my appointment order is at page 21, my lord, annex 4. This is the after the resolution is adopted, my lord. My lord, may kindly see you are hereby appointed as Arabic teacher. My lord has got the page, my lord. Arabic teacher at my school, Tapagon so and so by the managing committee held on 26/10/82 by its resolution number 1. This 26/10/82, my lord, had been recorded in the provincialization order, my lord. So therefore, my lord, there is no iota of doubt that there is any, my lord, my initial date of appointment can be altered or modified from 82 to 88, my lord. There is no, it is not permissible under the law, my lord. So which the director is now trying to do, my lord. I don't know for the what reason, my lord.
So you joined in 1982.
No, my lord, the resolution was adopted. My appointment was given on 7/1/1983, my lord. 7/1/1983, my lord. And thereafter I joined.
Yes, Sharma, PM Sharma, this government's letter 16/11/1991, by which the provincialization of the school and. Who is this letter? Because the petitioner is hinging on this 16/11/1991, saying that it is because of this approval that we have been given, and the director cannot override the approval of the government.
But Lordship, may I submit that on the basis of the data furnished by the then venture stage school, under which the government has no any authority. The service of the petitioners were provincialized in 1991. In 1991, he was measured. He was qualified in terms of age. But in 1983, he was under age. So he attained the age of majority or due to be qualified for the service in only in 1988. So whatever documents has been furnished by the school committee to the district level committee, at that stage, the government has no authority to verify the document of the venture school. On the basis of that, that recommendation has been given by the district scrutiny committee. And secondly, Lordship, in terms of this honorable court's order, in regard to the dispute of the seniority, there was a order of this honorable court in the instant petition to make an
Who
inquiry.
is that order?
Lordship, you kindly peruse, which my learned friend has already read out, paragraph number 11 of my affidavit. Affidavit in opposition. That as regards the amendment made in paragraph 11 of the writ petition, the deponent states that the petitioner was appointed as Arabic teacher by the managing committee, but at that time, of his initial appointment, the petitioner was underqualified, as the petitioner passed the HSLC examination only in 1983. It is further stated by the deponent that on 10/6/2022, after hearing the parties in the instant proceedings, this honorable court, 10/6/2022 order, Lordship, kindly bear with me. After hearing the parties in the instant proceedings, this honorable court was pleased to direct the answering deponent to make an inquiry by calling for the record of the service particulars of Topgam ME Madrasa and submit an inquiry report before this court. So in terms of this honorable court's order, an inquiry has been conducted and hearing was afforded to both the parties. And Lordship, this inquiry report is before your Lordship, which is at page number 73. The report of the hearing on 18/6/2022 in connection with WPC number 4241 of 2021 of Badr Ali versus so and so. Lordship, have your Lordship found it?
Yes.
Lordship. So this inquiry has been conducted in terms of this honorable court's order, where your Lordship will find in page number 74 the findings.
Can I have a look at this letter, government letter 16/11/90?
Lordship, allow some time, Lordship. I will place it
Next week?
next week. Lordship.
But we are consider.
The letter from provincial.
Priyan Chama,
Lordship.
then standing council,
Elementary education
elementary
department.
education shall produce the letter number EEG -567/91/104 dated 16/11/1991.
1991.
By this approval was given.
My lord, this is the sanction of the government for the purpose of
This is the
provincial.
sanction of, this is not specifically for this particular school, Lordship. Sanction of provincialization, Lordship.
By which sanction of professionalization of teaching and non-teaching staff
Lordship.
of ME School of Madrasa of Golbara district.
My lord, Bongaigaon, this is of Bongaigaon, my lord.
Bongaigaon.
Sanction is given only for a particular district or as a whole.
As a whole, Lordship. In person of the government letter.
My lord, at that relevant period of time, what is the, if this letter is brought on record, my lord, everything will reveal, my lord.
Yes,
My lord, that, my lord.
this the matter or when?
Lordship may fix on 28 Lordship,
28 will not be a,
28 Lordship.
it will not be a hearing, it will be a motion.
My lord, on 27th of June, my lord.
Lordship, 27.
My lord.
27.
And may I pray for a pardon as my lordship?
No, it's okay. It will come.
My-
It will
my-
produce.
Oblige me, lord.
2 and 3.
My learned friend has come here. I'll to do. This matter, your lordship, relates to the appointment of assistant professor in the Guwahati University, your lordship. Both these two cases are with the same appointment of assistant professor in the Guwahati University, your lordship. The first matter, your lordship, I'll take it up. This matter, your lordship, what has happened? Basically, my grievance is that I applied, I am an eligible candidate. I applied, but I was not even called for the interview. Basically, this is my grievance. Now, what has happened, your lordship, will kindly turn to the page 34. Sorry, page 23 for a moment, because I would like to show the biodata first. That is important. Page 23 for a moment. Page 23, your lordship will see his biodata. Dr. Satyajit Das. The academic qualifications, your lordship will see his results are second division, first division, second class, and first class. Your lordship. And as well as he has PhD degree. And also, your lordship, he has many academic achievements or publications and other things which are required for an assistant professor, and he is eligible for that. I'll come to the act a little bit later. First, let me put on the facts of the matter. So he applied, your lordship, his application. Now there is a process of sorting out the applications, your lordship. What?
There was an advertisement?
Yes, there was an advertisement. The advertisement, your lordship, will find at page 34. Page 34, this is on 12/6/2018.
Yes.
And then, your lordship, the serial number 12, that is at page 37. It is Department of Folklore Research. This is the type copy, your lordship. The other copy is annexed. I'm just reading from the type copy. Page 37, required qualification and specialization. Department of Folklore Research, Assistant Professor. Open, desirable, Master of Music and equivalent, and as per UGC norms. So qualification is as per the UGC norms. I'll come to that norms a little bit later. Let me see. So, your lordship. Now, what has happened after this application? I have made an application. Now, what has happened, your lordship? This application goes through the cell called IQAC of the university. They sort out the application. Shortlistings were done. So this is important. Once all the applicants apply, it is shortlisted by the IQAC cell of the Guwahati University, and they shortlist the candidates who are qualified, who are eligible, and then these names were sent to the selection committee. Then they were called for interview, and the selection committee takes the interview. This is basically the case. My case starts here because IQAC, I don't know what they have done, but I was not even called for the interview. When I came to know that the appointment has been issued, then I approached this honorable court saying that there was no select list was published, nothing was done. The person was appointed. Therefore, I come, and why I have not been called for. Now, your lordship will kindly take the affidavit in opposition of the university for a moment. The affidavit in opposition of respondent 1, 2, 3, and 4. Your lordship. I'll take your lordship to page 3, paragraph 4 directly. This is very important. That with regard, I'll just read this if your lordship allows. That with regard to the statements made in paragraph 6, 7, 8 of the writ petition, while putting the writ petitioner to the strictest proof thereof, the deponent respectfully begs to state that altogether 30 numbers of candidates submitted application for the post of assistant professor in the Department of Folklore Research, Guwahati University, with specialization, open, desirable, Master of Music and equivalent, so and so, so and so. Accordingly, as per said procedure, the applications were forwarded to the coordinator, Internal Quality Assurance Cell, that is IQAC, Guwahati University, for the screening of the candidates' suitability for the purpose of not merely assessment of eligibility,
but to maintain standard quality for recruitment. This was done to maintain a standard as per the decision of Guwahati University Authority, keeping in mind the relevant UGC regulations. In the instant case, the IQAC of Guwahati University forwarded its report after due scrutiny, having assisted by the experts concerned at the IQAC. It is stated that IQAC in its report shortlisted 16 numbers of candidates out of the 30 numbers of candidates, so that said shortlisted candidates could be called for the interview. While the writ petitioner Dr. Satyajit Das was not shortlisted with the remarks that he had weak academic career, also indicating that the grounds for rejection that he does not fulfill shortlisting criteria mandated by EC. EC means Executive Council. I'll show this. Moreover, as per the advertisement, so-and-so, mere fulfillment of qualification will not entitle an applicant for inviting to the interview, and consequently, the writ petitioner of the instant case was not called for the interview. So he was not called on the ground that my academic career is weak, and there is a shortlisting criteria of the EC executive, only these two grounds. Now I'll take your lordship to my reply. I have also filed the reply there. Kindly your lordship will take it up my reply for a moment.
Yes.
Para 5, your lordship. Page 3, para 5. I'll read it. That with regard to the statements made in paragraph 4 of the affidavit in opposition, the department begs to state that the respondent have not specified under what criteria 16 number of candidates out of the 30 number of candidates have been shortlisted by IQAC of Guwahati University. The department states that the IQAC of the Guwahati University cannot override the provisions of the UGC Regulation 2018. Clause 3.1 indicates as follows. This is the UGC regulation. Direct recruitment to the post of assistant professor, associate professor and professor in the university and colleges, and senior professors in university shall be on the basis of merit through an all India advertisement, followed by selection by a duly constituted selection committee as per the provisions made under these regulations. These provisions shall be incorporated in the statutes, ordinances of the university concerned. The composition of such a committee shall be specified in these regulations. As such, the UGC regulation have categorically discarded any other mode of selection and recruitment apart from which have been formulated by the UGC. So what it meant is that the UGC regulations that have been formulated by the UGC will have to be followed by the universities, though they can have their own regulations, but that should be in consonance with the regulation of the UGC. So that is why I am pointing it out, Your Lordship. Now, I'll provide the UGC regulation for a moment. Wait, continue. First is the UGC regulation of 2018, which is applicable in the present case. I'm not giving the whole regulation, the relevant part I am giving Your Lordship. Your Lordship will turn to page 59. This is the UGC regulation of 2018, which is applicable, Your Lordship. And I'll straight away go to page 59. The third page. Last paragraph, assistant professor. Eligibility.
Yes.
This is important. What is the eligibility of assistant professor? A master degree with 55% marks or equivalent grade in point wherever the grading system is followed in a concerned relevant allied subject from an Indian university or an equivalent degree from an accredited foreign university. 2. Besides fulfilling the above qualifications, the candidates must have cleared the National Eligibility Test conducted by the UGC or CSIR or a similar test accredited by the UGC like SLAP, NEP, SLAP, or who have been awarded a PhD degree in accordance with the University Grants Commission Minimum Standard Procedure of Award of MPhil PhD Degree Regulation 2009-16 and their amendments from time to time as the case may be exempted from NET, SLET and SET. So what has happened here? The petitioner is eligible and he has PhD. So otherwise he is not required to fulfill NET. So that is also, now your lordship will kindly go to B. There is an or and then B. Your lordship has seen B.
Yes.
B note. There is a note. This is important, very important. The academic score as specified in Appendix 2, Table 3A for universities and Appendix 2, Table 3B for colleges shall be considered for shortlisting of the candidates for interview only, and the selection shall be based only on the performance in the interview. Now, what it has stated that for shortlisting of the candidates, which was done by the IQAC, they have to follow this table. Table 3A for the university, 3B for the college. So since it is Guwahati University, your table will be 3A. I have given the table, your lordship will kindly take up the table for a moment.
Where is the table?
It's next page. I have an exit table.
Right.
Table 3A. Lordship has seen that?
Yes.
Yes. Criteria for shortlisting for interview for the post of assistant professors in universities. So here, your lordship, they have given the scorecard, how to score and what to do, how to shortlist the candidates. And your lordship, PhD marks. Below there is PhD, NET, SLET, how they will award the marks, and the number of candidates to be called for interview shall be decided by the concerned university. Academic score, next page, academic score and others, total this is 100. So if the total of 100, they'll have to give these numbers, your lordship. Where from your lordship, the IQAC found remarks to be given by them. They are not the interviewing authority. They're only shortlisting authority, and they have been given specifically, this is the shortlisting criteria. And this criteria, if applied, where from they have got the remarks, I have a weak academic career, it is to be decided by the selection committee. You see whether I have all these marks or not, and then you send it to the selection committee will select me in the interview. Now there's another, your lordship, document that I have provided to your lordship. Next, that is shown as EN2. Your lordship has seen that? This is they have said the second part. There were two parts. One is weak academic career, and secondly, Executive Council's decision. This is the decision of the Executive Council. The first meeting of the committee for finalizing following matters was held on so-and-so in the VC conference room at 3 p.m. 1. Shortlisting criteria for recruitment of assistant professor. Second is not required here. Third is application format for direct recruitment as per UGC regulations 2018. And fourth is IQAC scorecard as per UGC regulations 2018. So IQAC has got a scorecard as per the scorecard of 2018 regulation. They have also a scorecard made here. I have annexed it. Next page is exactly the same that the UGC has made. After this, where is the scope of putting in remarks that I am weak? I have a weak academic career. That is out of question, number one, and you don't send my name to the for qualifying in the selection committee. Now, your lordship, kindly go below in that minutes of the meeting, your lordship, kindly see that. The committee recommended for the shortlisting for recruitment of assistant professor to be based on a score of 100 marks distributed across 9 parameters. This is as per the UGC regulation. Now, your lordship will kindly see number 3. 2 is not required. 2. The committee recommended the content and format of the score sheet as indicated in Annexure 1. So that is the score sheet I have shown in the next page. Now 3. The committee recommended the maximum numbers of candidates to be shortlisted for interview be 10. So here in this EC resolution, they have taken that you can call a number of 10 persons to the interview. Now, the second part of that, the shortlisting of these 10 applicants will be done on the basis of their score on the score sheet. Candidates with a score below 50 as per score sheet will not be called for the interview. So they have given 2 points, 2 parts. One is 10 persons to be selected. Second is that person who will get more than 50 only they will be called less than 50 will not be called. Now, in my case, as per my assessment of this scorecard, because I have the knowledge of all my degrees, I have got 77 marks in this. So I am much more than the last required mark, that is, your lordship, 77 marks. So I am more than 50. So this is number one. Now what has happened to your lordship? They don't call me. Second part they have violated on their own is that they have stated 30 candidates apply. They should have, if they are following the EC regulation, they should have called 10 persons as per this regulation. They have called 16%. Why? Whom they are going to favor from the next 6 persons? So they are calling they're violating their own EC regulation. Number one. UGC regulation does not specify how many persons should be called for the interview. It has given the marks, the sheet whereby marks are given. You get marks, you are called for the interview. Interview will decide as per merit. So these 2 points, they have directly violated in not calling me to the interview. Number one. Now they might come up and say that we have called 16 persons. We are following the UGC regulations because UGC regulations does not specify how many numbers of candidates should be called for. Then how you are going to follow? What you are going to follow? You will call 30, or you will call 16, or you will call 19. With whatever you want, you will call. Or therefore, to systemize the whole thing, they have made it 10. You call 10 out of the top 10, whoever gets, he gets. Now you call 16. You don't even say I am more than 50 or less than 50. In their affidavit, they have not stated I've got marks more than 50 or less than 50. If I get more than 50, I am otherwise eligible to be called as per the UGC regulation. They have not done that. Now they say we are calling 16%. From which regulation? Your own regulation says 10. UGC doesn't say. UGC says more than 50. How can, where is the balance, your lordship? Now your interesting part, your lordship, will be if your lordship takes the second case. They've taken absolutely U-turn in the second case. That is why I'm first taking up this matter, then I'll come to the second one. Now, your lordship, very clear. One is the 2 grounds. One is that I have weak in my academic career, and second is they are following their EC resolution. The EC resolution says 10 persons, more than 50 marks. I am 77 marks. I'm more than 50. They have violated their own, calling 16 persons. As per the UGC regulations, I am otherwise eligible. So this point, now let us go to the second case for a moment. Very interestingly, they are taking 2 different opposite view in 2 cases.
Second case also facts are same.
Second case, facts are exactly the same. He was also not called for the interview. In that case, your lordship, he was a first class all throughout. In the second case, here he is a first class as well as a second class. It's a mix. So second case, I'm also going to show that in the first case, they are saying that they are following the EC guidelines and they have not called me and weak in my career. In the second one, they did not say anything like that. There they came up and said that no, 50, you have got less than 50 marks. That is why we have not called you. Very interesting. There they have called 10 candidates. They have followed the EC resolution, but saying that I've got less than 48 marks. I've got less than 50 marks. I got 48 marks. That is why we have not called. That is why I'm trying to show your lordship. Otherwise, facts are same. In this case, it is folklore. That case, it is Hindi. Second case, it is Hindi department. Same. I'll just show that. If your lordship will take up the affidavit, their affidavit. Just a minute. Affidavit in opposition of respondent 1, 2, 3, 4. Here your lordship will see that paragraph 3, page 2. Just 2 paragraphs I will read. May I read your lordship?
Yeah.
That with regard to statements made in paragraph 1, 2, 3, 4 of the aforesaid writ petition, while putting the writ petitioner to the strictest proof thereof, this humble deponent humbly begs to state that in the advertisement bearing so and so of the writ petition may be referred to, it has been inter alia stated that the minimum essential qualification is as per the existing UGC norms, and that in the event of large number of applicants against one post, the university reserves the right for shortlisting of applicants to be called for the interview. We are not against that. Very correct. Now the next paragraph, that with regard to the statements made in paragraph so and so, while putting the writ petitioner to the strictest proof thereof and also reiterating the statements made herein above, this deponent humbly begs to state that, as in all universities in India, screening activities of the application for the interview is carried out by the IQAC of the university. In the instant case, as per the report of the IQAC of the university, the writ petitioner scored 48 points on the basis of UGC regulation 2018 table 3A, page 107. I have already shown table 3A. Now they have used this UGC regulation table 3A, where they found that I have got 48 marks. It is stated that the writ petitioner scored 13 points in so and so, graduation 23 points, post-graduation 5 points in net, 7 points MPhil as per the said table of the UGC regulation, and the total points for his academic credentials is 48 points. In view of the said 48 points, the writ petitioner did not qualify to be called for the interview, as the cutoff mark for the purpose was 50 points. It would be relevant to point out here that in the note B of the said table 3A, number of candidates to be called for interview shall be decided by the university. Furthermore, it is stated that one so and so has moved the writ petition. This part, your lordship, is we are not concerned. So here they have clearly stated they are following 3A of the UGC regulation, and he got 48 marks. Now your lordship will see if in this case they are following 3A of the UGC rules. In my case, where is that? If they follow 3A of UGC rules, I get 87 marks. Why they have not stated anything in the affidavit showing that I have got 87 marks, you are not qualified, only 16 persons. In this case, they have followed this. They said 50, you're less than 50, you will not call, so you're less than 50. Here I'm more than 50, I'm 87. Why you have not called? Where is that? They have not replied anything. Now they have come to a different saying that weak academic career. From where from they are saying the weak academic career, your lordship? I will show one more thing. Lordship, in this case itself, your lordship will find the affidavit in reply. I'll show the persons they have called for interview who are third division candidates. My affidavit in reply, kindly take it up. Kindly take it up, your lordship, at page 24. This is also the assistant professor of the Hindi in this is on 36/2018, around the same period, your lordship. Page 24, your lordship has got that.
24?
Yes, of my affidavit in reply in the second case.
I'm on, yes, Para?
No, page 24 of the affidavit in reply is annexure 16.
Oh.
Reply affidavit, your lordship. Lordship had got that? This is the statement of candidates.
Yes.
Yes. These are the candidates who were called for the interview in the post of assistant professor, your lordship. In the second case, I'm saying, showing it, your lordship. This is here, your lordship. The first page 24 is a good academic career, is first division, second division, first division, like, or more or less like me, your lordship. I have nothing to say. Now, your lordship will kindly take page 26. Serial number 3, your lordship. See, Rajiv Kumar. His third division, first division, second division, third division. Then your lordship will turn to page 27. Serial number 6. SSLC third division. Then serial number 7. SSLC third division. Your lordship, I don't have a third division in my entire career. I am either a first division or second division. You are calling people of third division and they don't have a weak academic career. And I am a first class and a second class all throughout. And you say I have a weak academic career. What kind of a selection is this, your lordship? Whatever they want to do, they will do it. within the garb of saying we are following UGC norms 3A, and in the other case, they will come and say, no, we are following 3A and you have got 48. Fine, I've got 48, reject my second matter. But what about the first case? I have got 87 marks. Why you have not called me? Here you call 30%. There you call 16%. Somewhere you will call 11%. Somewhere you will call 50%. What is that? If you follow the guidelines of the EC, Executive Council, you call 10%. Don't make it beyond 10. Then if I qualify within my 87 marks, call me or don't call me. You have no right, the IQC have no right to say you have a weak academic career, you have this and that. Then second part, your lordship, yes, if you are calling 16%, why not 30%? Where is the bar? There is a bar of less than 50 marks. I have got more than 50 marks. Call all the persons who have got more than 50 marks. Then if I select in the interview, fine. If I'm not selected, go on. You are not calling the persons for the interview on whimsically on making one point or the other. In one you say with 3A, one you say EC. Why say no? You have a weak academic career. Where from you have done all these, your lordship? This is my case in both the cases, your lordship. Second matter, if I actually got less than 50, obviously I don't have a claim. So it goes. Your lordship may dismiss that case. But first case, he has got 87 marks. Why he has not been called for the interview? This is basically my whole case, your lordship. Let them answer the questions. Why they have followed two different procedure in two different selection of the same universities during the same period of time. And secondly, your lordship, how can the IQSC go beyond the UGC regulations? This is basically two things. If required, I'll give my reply.
Yes.
Regarding the first case, the first case, the advertisement, kindly turn to the advertisement. Annexure 3, page 34. The first case, kindly see the date. The advertisement was of 12/6/2018. And the second case, the advertisement was of 2020. It was of June 2018. And in second case, the advertisement was of 2020. And UGC regulation was of July 2008. So, my lord, UGC regulation 2018 is applicable to the second case. And UGC regulation 2010 is applicable to the first case. That UGC notification 2018, it was of dated 18 July 2018. And the advertisement was 12/6/2018. Page 34. And in the second case, the advertisement was dated 2/6/2020. Now, I take your lordship straight to my affidavit in opposition in the first case. Paragraph 4. He has already read the paragraph 4 from his perspective, my lord. Page 3, paragraph 4. May I read again? Page 3, paragraph 4 of my affidavit in opposition, first case. With regard to the statement so and so, strict proof thereof, the opponent respectfully begs to state that altogether 30 numbers of candidates submitted application for the post of assistant professor in the Department of Folklore Research, Guwahati University, which specialization open. Second paragraph, subparagraph. Accordingly, as per said procedure, the applications were forwarded to the Coordinator Internal Quality Assurance Cell IQSC, Guwahati University, for the screening of candidates' suitability for the purpose of not merely of assessment of eligibility, but to maintain standard quality for recruitment.
This was done to maintain a standard as per the decision of Guwahati University Authority, keeping in mind the relevant UGC regulations, not UGC regulations of 2018. At the relevant time, that UGC regulation of 2010 was applicable. In the instant case, the IQAC of Guwahati University forwarded its report after due scrutiny, having assisted by the experts concerned at the IQAC. It is stated that IQAC in its report shortlisted 16 numbers of candidates out of 30 numbers of candidates, so that said shortlisted candidates could be called for the interview. While the read petitioner Dr. Satyajit Das was not shortlisted, with the remarks that he had weak academic career, also indicating the grounds for rejection. Next page, Miller. Also indicating the grounds for rejection that he does not fulfill shortlisting criteria mandated by EC. Moreover, as per the advertisement, Annexure C of the writ petition may be referred to. Mere fulfillment of qualification will not entitle an applicant for inviting to the interview, and consequently, the writ petitioner of the instant case was not called for the interview. Now, if we turn to the advertisement, writ petition page 34 onwards, Miller. The last page, Miller, page 39. May I read, Miller? Those who are willing to apply for more than one post, they must submit separate application form with separate application fees. Name of post and departments must be written on the envelope. For candidates who will be applying for the post of professor, associate professor, Miller, we can skip these things, Miller. The last but one sentence, Miller. Mere fulfillment of qualification will not entitle an applicant for inviting to the interview. Reservation policy of university will be applicable, and Guwahati University reserves the right not to fill up any or all the advertised posts due to administrative exigencies, and no claim can be made against the same by any person applying to the post. So, Miller, that sentence, Miller, mere fulfillment of qualification will not entitle an applicant for inviting to the interview. So, Miller, shortlisting of the candidates have been done out of 30 candidates. Miller, 16 were selected, Miller, and this was done as per UGC regulation 2010.
Where that UGC regulation?
Miller.
2010?
I don't have that regulation right at this moment, Miller.
Second part is, you said that you followed the
UGC regulation of
mandate of
2010.
the executive council. Correct.
Second case,
First
2008.
case, first case.
First case,
Your affidavit in reply clearly indicates in opposition, paragraph 4
4,
at the last part,
Miller.
that does not fulfill shortlisting criteria mandated by EC,
Yes, Miller.
Executive Council. Now we've seen the Executive Council's resolution. There it says 10 candidates.
Miller,
How did you exceed 10?
Miller, that EC resolution, Miller, has not been annexed with the
The
affidavit.
copy has been given. You have another spare.
I have another copy. I have. Actually, he is the
I'll have to
council,
go
they
through
should
the-
have the EC, because he has stated here mandated by EC. So he should have had the copy of, he should have annexed it. Anyway, I'm giving him a copy now, your lordship.
The minutes. Serial number 3.
It was dated 22 November 2018. Advertisement was of June 2018. UGC regulation came into effect in July 2018. So it was after the coming into effect of UGC regulation 2018.
No, that is a different thing. But the decision of the Executive Council recommended that maximum number of candidates to be shortlisted for interview be 10. How have you exceeded 10?
My lord, it is not EC resolution, my lord. No, I'll have to obtain instruction regarding this document, my lord. It
Where's
was,
the executive council's resolution then?
my lord,
Where's the executive council's resolution?
this,
Executive council resolution. Yes, you have
Because
stated.
he has craved leave of this court to refer and rely upon that. In fact, that paragraph,
Yeah.
the crave leave of this honorable court.
my lord,
I have produced, he is not yet produced, I think.
particularly regarding this document, I will have to obtain instruction, my lord. And regarding EC resolution, my lord, I don't have the resolution right at this moment.
You should
but
have
the-
it. Here you have specifically in paragraph 4, you've said as mandated by the executive council. If you said that this is not the executive council, then where's the executive council resolution? Let us have a look. Let us have a look at the reports also.
The page 3, my lord. Screening of candidates suitability for the purpose of not merely assessment of eligibility, but to maintain standard quality for recruitment. This
Huh?
was done to maintain a
Page
standard, page 3, my lord.
of your affidavit in
Yes, my
opposition.
This was done to maintain a standard in the middle portion. my lord.
Hmm.
4, paragraph 4, subpara 2, my lord. As per decision of Guwahati University Authority, keeping in mind the relevant UGC regulations. In the instant case, IQAC of Guwahati University forwarded its report after due scrutiny, having assisted by experts concerned at the IQAC. It is stated that IQAC in its report shortlisted 16 numbers of candidates out of 30, so that shortlisted candidates could be called for the interview, while the writ petitioner was not shortlisted with the remarks that he had weak academic career. Also indicating the grounds for rejection that he does not fulfill shortlisting criteria mandated by EC.
Where is this?
So that mandated by EC, it was, this document was of November 2018. But
No,
this
but where,
IQ,
then where is your document? Where is your executive
Well,
council resolution?
my lord, I will have to produce that document, my lord.
Not only that document, you have to produce all the records. IQAC, IQS. report.
IQAC as well as the EC resolution.
Yes,
I'll produce, my lord.
all relevant.
Day after
records.
tomorrow, my lord.
One more thing I'd like to point out, subject to what he has said. My learned friend is showing that the advertisement is prior to the UGC regulation, your lordship. What has happened, your lordship? After the UGC regulations came into being, the advertisement was prior to that. I have nothing to say that it's correct. But subsequently, all the procedures were done after the UGC regulation, and it is a prospective effect. And the interview was held in 2020. The interview was held in 2020, appointments were made in 2022. So, in other way around, if my learned friend can show by pointing that in 2010 UGC regulation, the IQAC has something to do with regard to this type of selections, then I have no case. But as per what I know, I don't have the regulation 10 with me now. There is nothing like IQAC's relevancy of these things there. They have in fact applied this. Now they are, in order to go out, they are applying 2010. Let them show it. I have nothing to say. Lordship will fix it a day whenever he has the records. Let them show it.
I'll produce the relevant records, my lord, including the EC resolution as well as IQAC report, day after tomorrow, my lord. And regarding this document, my lord, is IQAC report, not EC resolution. And it
That
has not
also
been,
you take instructions on that. How long? By day after tomorrow, can you take all the instructions and produce the records?
my lord.
Mangalbar fix video next Mangalbar. Next Mangalbar video, get the records. Otherwise, any time will have me. Next Tuesday video.
On
Next
Thursday, my lord.
Tuesday on
Third wise
Thursday.
Manan Learning Council for the.
Thursday করে না আমরা কিছু একটা না থাকি নেক্সট উইক না থাকি
next week.
না থাকি
Next week Tuesday. Tuesday kuch.
না 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 থাকি
Ketia thaki.
থার্সডে দি দিয়া
He wants it day after tomorrow. Let
ডে
it.
আফটার টুমরো my lord.
On request made by Mr. Fiji Fukan.
my lord.
Then it's standing council, Guwahati University, please the matter again on. Thursday is what, 15th
15th, my lord.
June. To enable him to produce all the relevant reports, including the UGC regulation 2010. as well as the executive. I don't know what, which executive council is it?
When EC, whatever they have not given date.
The relevant EC,
I'm not saying anything, I'm just saying all relevant records
Milord,
along with the
relevant EC
UGC regulation of 2010.
10.
Okay.
Milord.
So that includes the executive council resolution,
Milord,
IQAC records
Milord,
in both the cases, both cases.
both the cases. Milord, I'll produce.
May it please, Lordship. In this case, Lordship, I am appearing first case, ESCOM number 5. I have been selected and appointed, Lordship, early 1 year ago. In this case, Lordship, by court order, I have been appointed, Lordship, and all through my academic career. Of course, he is arguing this matter. He has not been shortlisted. Prejudiced. If he is prejudiced, then in all throughout the career from first, I am first division, first class. So affidavit is required from my part, Lordship, because he has not made party to me.
What is it?
He has not made party because in this that time selection was not made, Lordship. So by this court order, I have been appointed. So Lordship may grant time to file affidavit, additional affidavit, so that I can bring my records.
No, are you not a party in this?
Yes, he's
Originally not.
He's a part. Originally, he was not there,
Originally,
but
I was
later on,
not.
he has implicated himself as a
Yes,
part.
Lord.
The respondent 5.
Lordship, originally not, Lordship.
Originally, at that time, he was not
a single
appointed.
sentence has been
1 minute.
against me, Lordship. So I have been implicated, so my academic record has to be brought, Lordship. First class, all the first class 10 star marks, because he has a second class category,
You
Lordship.
have not filed your affidavit.
No,
I
he
have
has filed.
filed,
He has filed.
You filed your affidavit.
I have filed, Lordship, but in this affidavit, Chief, my academic career has not been recorded, Lordship. So I want to have additional affidavit, Lordship. Additional affidavit, so that I can bring my academic record.
Then that will take long. It can't be there for tomorrow.
He has showing this his academic career. Otherwise, he has not blaming against any one sentence against me. I have no objection. Rightly, my Anathan has not given any objection.
My case is.
Tomorrow I can file.
UGC.
Tomorrow I can file, Lordship. I can. Tomorrow I can.
Let him know tomorrow. Let it be day after.
Additional affidavit.
In the meantime, Mr.
D. Mahanta.
D. Mahanta, council approving for respond number 5 in WBC number
First one, you know.
2348.
2348.
Is permitted to file an additional.
Lordship will keep it as part.
That will come up.
Otherwise,
Sometimes it's dangerous to keep part heard.
I understand. But since we have already argued the whole matter, that is. Much obliged. You.
Bye.
Also, madam, timing also. Okay, who is paying this? A Google is paying for the. Oh. Who is paying this?
My pleasure, Lordship. This is the second round of litigation, my lord. In the first round, this honorable court directed the Director of Higher Education to adjudicate the inter-se seniority between the writ petitioner and the respondent number 6. And thereafter.
Where is that order?
My lord. That order is at page 70, my lord, NHS 17. Page 70. The earlier writ was filed by the respondent number 6, my lord. The relevant provision direction is at paragraph 8, my lord, page 72. If I may read, my lord.
Yes.
Accordingly, the writ petition is disposed of by directing the Director of Higher Education, Assam, to verify the claim of the petitioner by hearing both the petitioner and the respondent number 5. I was the respondent number 5 in that writ petition, my lord, as well as the college authorities, and also by taking into consideration the Assam College Employees Provincialization Rules 2010. And if Upon such verification, it is found that the petitioner is indeed senior to respondent number 5. Appropriate order will be passed by the Director of Higher Education, Assam, reviewing the order of provincialization dated 26/5/2014, as far as the petitioner and the respondent number 5 are concerned. Thereafter, a hearing was conducted by the director, my lord,
Where is that?
and the speaking order was passed, Annexure 20, page 76. Page 76.
Yes.
If I may read the entire thing, my lord, it's a small order. It is dated 22nd of October 2021. Speaking order. Read the Honorable High Court order dated 18/11/2019, passed in WPC number 4272/2014, filed by Niva Kalita, says respondent number 6 presently, wherein the Honorable Court directed the Director of Higher Education, Assam, to verify the claim of the petitioner by hearing both the petitioner and the respondent number 5, as well as the college authorities, and also taking into consideration the Assam College Employees Provincialization Rules 2010. And if, upon such verification, it is found that the petitioner is indeed senior to the respondent number 5, appropriate order will be passed by the Director of Higher Education, Assam, reviewing the order of provincialization dated 26/5/2014, as far as the petitioner and the respondent number 5 are concerned. My lord, we are provincialized by this order, wherein I was placed above her, and therefore she had challenged in the repetition, and therefore these proceedings were conducted. Whereas in compliance of the Honorable High Court order, a hearing was held on 24/3/2019. It should be 24/12, my lord. The date is mistaken, my lord. Anyways, Niva Kalita, the petitioner, Hasnur Ali, he is the present petitioner, my lord. Hasnur Ali Chaudhary, the respondent number 5, Shri Binod Kumar Gogoi, President of the governing body, and Ashit Kumar Paul, Principal of BC Medi College, has attended. So the college authorities, the respondent and the petitioner all had attended the hearing, my lord, before the director. Observed and examined all the documents and written statements submitted by the incumbents and heard the persons at length. It is found that Niva Kalita and Hasnur Ali Chaudhary were appointed by the college authorities as junior assistant on 26/4/1997, and both of them joined in the college on the forenoon of 30/4/1997. In the document submitted by the college authorities for provincialization, the name of Hasnur Ali Chaudhary was reflected above the name of Niva Kalita. They were appointed in the same selection process, same advertisement, and they joined the college on the same day, 30/4/1997. Whereas the date of joining of Niva Kalita and the petitioner and Hasnur Ali Chaudhary, the respondent number 5, is same, but the date of birth of Niva Kalita is 1/1/1976, and the date of birth of Hasnur Chaudhary is 1/1/1977. It appears from the date of birth that petitioner Niva Kalita is senior to the respondent number 5 for having the same date of joining. In compliance of the Honorable Court's order and taking into consideration the Assam College Employees Provincialization Rules 2010, the matter is disposed of with determination of inter-se seniority as Niva Kalita is senior to Hasnur Ali Chaudhary. Accordingly, steps may be taken for due consideration in provincialization. With that, the Honorable High Court's order dated so-and-so, passed in so-and-so, is complied with, and the prayer petition of Niva Kalita dated 25/11/19 is disposed of. I am agreed by this order. They have considered only the date of birth, whereas the rule says something else. I'll place those before I place the facts, my lord. My lord, pursuant to an advertisement in the Venture College, my lord, the advertisement is at page 23, my lord. The college was at a venture stage at that point of time, my lord. Page 23.
Yes.
This is an advertisement dated 24/4/1997. The application, along with attested copies of mark sheet, certificates and other testimonials from HSLC onwards, are invited from local candidates for the post mentioned below, and the same must reach the undersigned within 7 days from the date of publication of this advertisement. I am concerned with serial number 2, my lord, lower division assistant. Both of us applied for the same post, lower division assistant. And there were 4 number of posts at that point of time, my lord. There were certain conditions which were given in the same advertisement, my lord. I would like to place serial number 3, the last line, my lord. A few posts are reserved for donor member as per resolution of the managing committee, my lord. Some posts were reserved. So out of these 4 posts of LDA, 2 posts were reserved for donor family members. I'll place that also. Pursuant to this, we appeared in the interview. And after the interview, a resolution was taken by the college. The resolution is at page 25, my lord. Page 25. Resolution number 4, my lord, will be relevant. It is resolved in today's meeting that pursuant to the local advertisement, the below mentioned candidates are selected for appointment to the respective post based on their merit. So on the basis of merit, the petitioner Hasnur Ali Chaudhary was at serial number A, and below him, the respondent number 6 is there. The rest of the C and D, Raman Medhi and Riten Medhi, were the landowner family members. So they were selected on the basis of merit. There is a discrepancy between the petitioner and the respondent, and they say it should have been eligibility. This type copy was in Assamese, originally is in Assamese. So they say it should have been eligibility, not on merit. But to counter that, I can say resolution number 5, 26 at page 26. Resolution number 5 says, it is resolved that if the selected candidates for appointment do not join their post within the time specified, in that case, the next candidate in the merit list. So the managing committee has considered that there is a merit list. And these are the selected candidates, 1, 2, 3, 4. If they do not join, the other candidates in the merit list shall be called for joining. Accordingly, my lord, the appointment letters were issued at page 29.
This translation is under dispute. Or?
Yes, my lord.
That one.
My lord, this
in
will
resolution
boil
number
down
4.
to the translation of this Assamese version. Because my learned friend's translation is, it is based on merit, on their merit. But if I may read the Assamese, it says, Ullekhat podhamuk jogyota bhiktik. That, my lord, is on the basis of eligibility. Jogyota is eligibility. Jogyota bhikti, that is on the basis of eligibility. If had it been jogyota onukari, then it would have been on the basis of merit. It would all boil down, my lord, the decision of this case would boil down to the vernacular version. And my learned friend's submission that it is based on merit is incorrect. If my lord, my friend finishes, then I may address on that, because this is not a merit.
What about the resolution 5?
Resolution 5, my lord. Resolution 5, it says, if I may read the Assamese portion. Jogyota aru okol bhiktit medha talikar, that is merit listot thoka nijukti dia hobo. Now, my lord, the resolution number 4, it is a select list of the persons who have been selected. This is not the merit list. Reason being, my lord, my affidavit in opposition, the government's, the government, while provincializing, it had taken, if my lord takes up my affidavit in opposition.
No, I'll come back to you.
My lord, here it is the donor family members, 3 and 4. Had it been a merit list, it would all have been on the basis of merit. Donor family members would not have come. So this is not on the basis of merit. This is on the basis of eligibility. So, my lord, this would all depend, my lord, on the translation of this vernacular version. The decision of this case would depend on that.
If I may place the vernacular of the resolution number 5 at page 28, my lord.
I can't.
The fifth line, my lord. It says Medha Talika merit list. In English, it is written. It is written in English. From the merit list, they will be selected if the selected candidates do not come, my lord. So it is there. Accordingly, my lord, the appointment letters were issued. Appointment letter, my appointment letter is at page 29, my lord. I'll just place the reference number, my lord. Memo number BCMC 1280B. In respect of the respondent number 6, which is at page number 33, my lord. The reference number is C. So see, in seriatim, I was given the letter first and C was given the letter later. It is undisputed that both of us joined on 30th of April, 1997. And till the date of provincialization, we worked together, madam. There is no discrepancy on that. Now, if I may place the provincialization order, my lord, that is at page 56, Annexure 11. In exercise of the authority conferred under provision 4.1 of the Assam Venture Educational Institution Act 2011, as amended in so and pursuant of government sanction letter dated so, the services of the following employees of Binandi Chandra Medhi College, Ramdia, District Kamrup, have been provincialized, and they become the employees of the state government with effect from 14/8 to 2013, with the following terms and conditions as mentioned below. They are also entitled to draw a minimum scale of pay and allowances as admissible under the rules with effect from 14/8/2013. So it was given a backdate effect, my lord. The letter was of 26 May 2014. It was given effect from 14/8/2013. And I'm at serial number 14, my lord. I was given the post of senior assistant. And the respondent number 6 at serial number 15, my lord. She was given the post of junior assistant, my lord. Being agreed, she had filed the earlier writ petition. Now, if I may place the rules.
Yes.
Assam College Employees Provincialization Rules 2010, my lord.
Yes.
If you're carrying the same book, my lord, 496.
Yes.
My lord, Rule 17 talks of seniority, my lord. Rule 17 at page 501. The rules talks of two scenario, my lord. One where there is a merit list and the other where there is no merit list. So I'll place the first 17A. Inter se seniority of employees belonging to each of the cadres shall be in order in which their names appear in the select list. Here there is no merit list. In order of their selection, their seniority will be considered as prepared by the selection committee, provided he or she joins in the post within 15 days from the date of receipt of the appointment order or within the extended time. So there is no dispute. If the selection committee selects us in a seriatim, the one above will be senior. Now, in the second scenario where there is a merit list, my lord, that is C, my lord, 17C. If two or more persons are bracketed in the merit list, so they have got same marks and they're bracketed, my lord, by the selection committee, the inter se seniority of these persons shall be determined according to the date of birth. So the contention of the respondent number 6, that since she is elder to me in age, she should be senior. They have to satisfy that there was a merit list and both of us attain the same merit. We are bracketed in the same category, and then her date of birth, considering her date of birth, she will be considered senior. But in the present case, they say there is no merit list. It is just a select list. Now, according to 17A, since there is a selection by the selection committee in a sort of seriatim, I am being in the top, I should be senior to her.
So both counts,
On both counts, I shall be above. This much I have to please on. I'll reply.
but
once-
then in the
no,
translation, there's a dispute, isn't it?
in resolution number 4. So if they dispute that and say that there is no merit list,
Then
I presume that there is no merit list.
Nair,
My,
we can have it translated by a neutral body.
yes, my lord, that would be in order. Let the official translator,
Who is the translator?
there's a translation department, my lord.
No, it's Translation wing. But Mr.
B. Prasad Manu.
You Prasad Leonard Council. Also heard. The higher education who appears. Yeah. Yeah, Tapildar, Standing Council, Higher Education Correspondence, 1, 2, 3.
I am for 4 and 5. That is it. 4 and
Mr.
yeah.
Z. Hussain, Leonard Council for the respondents, 4 and 5.
I'm for
And
6.
Mr. P. D. Nair, Leonard Council for respondents. During the course of hearing, there's a dispute between the petitioner and the respondent number 6 with regard to the translation of
Annexure 2, resolution number 4,
annexure number
Page
2,
25.
Annexure 2
the original is at page 27, madam.
of translation of
Resolution number
annexure
4,
2 within bracket page 27.
27 and 28, my lord. Both
27 and 28,
resolutions 4 and 5.
particularly with regard to resolution 4 and 5. Stop. Accordingly, forward. The translation wing of this court is directed to translate the vernacular portion of annexure 2 within bracket page 27 and 28 within a period of translate into English within a period of 2 weeks. Will it suffice?
No.
Only it come after the winter.
After
After the vacation,
but let them complete it within
the
this period,
period of 3 weeks. Stuff. You want a date?
mine,
after the vacation.
Mine. After the vacation.
When do you want?
Around 18 or 18.
That week will be quite. This is the matter, you know. You only don't know hearing day,
On the hearing,
Let
they
it
would
be
be
on
better,
hearing
my
day.
lord.
27th July.
My lord. Deeply
Not
obliged.
interim, my lord, the interim may continue.
You have an interim order passed. Right? Continue to the-
Deeply obliged.
Yep.
May I plead your lordship? The petitioner before your lordship praying for provincialization of her service as assistant teacher science in ME school under Sirang district, my lord. The petitioner's school was provincialized in 2013, my lord. At that time, she was left out because of underqualified. But there is an official memorandum, my lord, where it was stated that is annexure 8
Uh,
is 32, my lord.
Vajrabara,
Yes,
whether the respondent number 8 has
Yes.
had any absence.
Respondent number 8. The headmaster of the school, but no, he has not appeared, my lord, but the director of BPC filed an affidavit and they have complied the statement made in the petition. And lordship, in this case, the similarly situated person has, this court has passed the same order in the similarly situated person, my lord. The matter may be disposed of in the light of this. At the motion stage, my lord. That matter may be was disposed of at the motion stage, my lord.
Lordship, I've got some instruction here.
Prior to 2001, in a BSc, right? Prior to 2000, now, join a court for it. She has come up with some pending things.
Itu কি কন্ডিশন bisa আইন তো বিচাৰি পাগল হৈ গৈছো সুবিধা কোনবা লৈছিল এডুকেশ্যন
Petitioner was appointed by the concerned school managing committee as science teacher of Provincial School on 14/6/2010.
What is your instruction?
Lordship, here, on the last occasion, we were asked to bring the, what is the qualification? So, for the qualification, your Lordship, if your Lordship peruses the first page, your Lordship, it is given there that for the Minnesota State Level Committee for considering permission, recognition, upgradation, concurrence of educational institution. Qualification of science teacher in upper primary school prior to August 2010 is BSc. In case of non-availability of qualified science teacher, graduate teacher, HSSLC, science past teacher were allowed to act as science teacher. Lordship, for those which were opened prior to 2000. Lordship. So here, your Lordship, if your Lordship sees her own petition, my lord, she has been appointed by the concerned school managing committee as science teacher of Kujurparaguri ME School, Chirang on 14/6/2010. 14/6/2010. And accordingly, she has joined as science teacher at 14/6. So, you know, she's joined on 14/6. So this notification says that she had to be BSc. She was not at that point. So she's underqualified automatically. That's why she is not qualified. That is my content.
Lordship, there is a letter from the Director of Elementary Education Assam to the District Elementary Education Officer, all, my lord, that is page 27, annexure 5, where it was stated in B that there shall be one science graduate teacher to each science and mathematics. In case of non-availability of qualified science graduate teachers, SSLC science plus teachers may be allowed to act as a science teacher for those schools which were open prior to 2000, my lord.
Exactly.
Prior to
What
2000,
you were appointed on?
which were
2010.
open, my lord. School was
Doesn't
open
qualify.
prior to 2000. The petitioner school was established in 1965, my lord. 1993. The prior to 2000, my lord.
And her mention, my lord, she has joined. Petitioner was appointed by her own statement at paragraph 3.
Yes,
What is,
but here
she
in
has
this,
been appointed
letter.
by the school managing committee as science teacher of Pujurgarapuri ME School on 14/6/2010.
No,
She doesn't qualify.
no, here, Fukan.
My lord.
It says a science teacher for those schools.
Mhm.
For those schools which were opened prior to 2000,
Prior to two
for
thousand.
those schools, not for those teachers.
Not
My lord,
teachers,
for those
schools.
schools, that means prior to 2000, they were accommodated as, supposing there was no
For
availability,
those
then they were accommodated.
schools-
But
For
this is-
those schools
Huh.
which were opened prior to 2000,
Exactly. Prior
Yes.
to 2000, so people who did not have science qualification BSc,
they can
they were
apply.
accommodated as HS Science, they were also taken in.
Yes.
But in this case specific, if you see your chip, the school, the person has joined a science teacher on 14/6/2010. That is after,
No,
No.
and
I'm not saying about this teacher joining.
my lord,
I'm talking about the school opening of the school.
my lord,
School was opened in 1993.
93,
Yes, my lord.
that is true.
You read it properly.
Established in 94, 6/1/94.
It says teachers may be allowed to act as science teacher for those schools
My lord.
Hmm,
which were opened prior to 2000.
hmm. So I
So
am.
it's for those schools only,
Yes,
prior, who had opened prior to 2000,
Yes,
not those teachers who joined.
yes.
my lord.
And my lord, another,
Now, let us see your case. You proceed with your case.
yes, my lord. The petitioner school was provincialized in the year of 2013, my lord, under 2011 Act, my lord. And at that time, the petitioner service was not provincialized, as at the relevant point of us, he was underqualified. But an office memorandum which was issued on 19 November 2014, my lord,
Where is that?
is 32 Annexure 8. Where
1 minute.
is 32, my lord,
Oh,
Annexure 8. Where 4(3), column 4(3), when bottom, provided that if an employee is required to acquire any prescribed academic or professional qualification, service of such employee may be considered for provincialization if otherwise eligible. But in such case, the provincialization would be subject to acquisition of such prescribed qualification within a period of 5 years from the date of coming into force of this act. Accordingly, petitioner acquired the BSc degree from Guwahati University, my lord. Thereafter, my lord, the secretary to the regarding qualification, thereafter to the secretary to the government of Assam, the annexure 9, my lord, page 34, regarding qualification of science teacher of upper primary school. With reference to the subject cited above, I have the honor to state that a letter was issued by the director by so-and-so, 28/12/2007, where it was stated that due to non-availability of the qualified science graduate teacher, SS science pass teacher may be allowed to act as a science teacher of those schools which were open prior to 2000. And thereafter, the district elementary education officer submission the proposal of 7 numbers of drop science teacher to the director of elementary education office education Assam Kahilipura 35, where the petitioner name was there. The commission thereafter, my lord, the director submitted a proposal for provincialization of those 7 drop science teacher working in newly provincialized upper primary school under Sirang district. Accordingly, thereafter the earlier act was no longer in force and new act was introduced by the government of Assam, and advertisement was issued on 31st May 2017, that is page 41, my lord, where it was clearly stated that Assam Bhansar Educational Institution Provincialization Service Act 2011, but their service have not been provincialized, may submit their application for provincialization of their service under new act of 2017. The Assam Education Provincialized Service Teacher Reorganization Education Institute Act 2017. Accordingly, my lord, the petitioner has submitted duly fill up with a proper format before the district level scrutiny committee and district level scrutiny committee and the District Elementary Education Officer thereafter issued a letter to the Director of Elementary Education Officer on 9th January 2020, that is for page 47, Annexure 18, where submission of particulars of 13 numbers of dropout science teacher working in newly provincialized MEM school for provincialization of their service. With reference to the subject cited above, I have the honor to submit here the particulars of 13 numbers of dropout science teacher working in MEM school for provincialization of their services who were left out at the time of provincialization during 2013 as per prescribed pro forma Annexure 1, my lord. In this regard, it is stated that the proposal of the aforesaid teachers had already been submitted to your end by this office on duly scrutinized by District Scrutiny Committee Srirang. This office by letter number so and so dated 28 November 2000 along with a statement Annexure B, my lord, where the petitioner name was next page 48, serial number 12, my lord. So petitioner is still working in the said school, my lord.
Did you acquire your BSc? Have you acquired BSc?
Yes, my lord.
From which college?
From Guwahati University in the year of 2016, my lord, Annexure 22, Annexure 1, page 22. And he has also completed her DLED, my lord.
Two 2016.
Yes, my lord. From Guwahati University.
You have also completed your
2016, my lord, BSc final semester
and DLED.
and DLED, my lord, DLED on 25/9/2020. And petitioner was appointed on 14 June 2010. And joining is 14/6/2010, my lord, same day.
Yes, Fukan.
Lordship, looking at the facts now, my lord, we can do one thing, Lordship,
Let the director consider.
consider the matter, my lord, and upon due verification.
Lordship, kindly maybe dispose of the matter along according to the order passed by this court and the similarly situated person in the same school, same district, my lord. And
You are in which school now?
school Kharwaja, okay,
Khujurapuri
ME school. But Lordship, in a semester, there is a typical error, two typical error. The school was established it was written in 1965 instead of 1993, my lord. I may be allowed to correct by hand and the concerned school managing committee as a science teacher on 14/6/2010. It was written as 29/5/2002. That was a typical error. I may be allowed to correct, my lord.
Yes, hurt MS. Also heard Mr. A. Fukan.
My lord, A Fukan for respondent 1, 1 and 3, my lord. 1, 3 and 4. 1, 3 and 4.
1, 3 and 4.
My lord, 2 Mr. Finance.
Finance. Mr. R. Borbojari, the standing council of finance, appears for respond number 2.
I am
And
5, 6 and
MS
7.
R. Bora. The
Respondent 5, 6 and 7.
standing council BTC for respondents 5, 6 and
I'm sorry, so I do update.
stop. Para. The petitioner was appointed as a science teacher of Khajuraho, correct? Khajuraho,
My lord.
Khajurapuri,
ME School, comma, Chirang. On 14/6/2010. To which post he joined on the same day.
Khajuraguri.
You joined on the same date, correct?
Yes, same day.
Since then, comma, petitioner has been continuing, has been serving as a science teacher till date. Stop. But the Khajuraho ME School, Chirang, was established in the year 1992 and was provincialized on 1/1/2013.
Yes, my lord.
1/1/2013. Stop. However, the case of the petitioner could not be provincialized as she was found not qualified. Stop. The provincialization of the school of petitioner was carried out, was on the basis of the Assam Venture Educational Institutions within bracket provincialization of schools, provincialization of service or schools,
Provincialization of service,
provincialization of service, close bracket Act 2011.
11.
Hereinafter referred to as the Act of 2011. Stop. However, comma, in the meantime, the Act of 2011 has been declared null and void by this court. Stop. In the meantime, accordingly, a new enactment has already been made by the government of Assam. And namely, the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions, close bracket Act 2017. Stop. The petitioner, in the meantime, acquired her BSc degree from the Guwahati University in the year 2016. Stop. She also acquired DLED from the National Institute of Open Schooling in the year 2020. Stop. Stop. As such, comma, by this swift petition, petitioner is praying for a direction to the respondents for provincialization of his service under the provisions of the Act of 2017. Stop. Para. Where's the director's letter? Director of Elementary Education. Advertisement.
Advertisement. Advertisement on page 41.
In the meantime, issued an advertisement
31 May
on
2017.
31 May 2017, calling for applications from teachers whose educational institutions have been provincialized as per the Act of 2011, but whose services have not been provincialized, were allowed to submit the application for provincialization of the services under the new Act of 2017. Stop. You've met your application,
Yes, my lord. That is an annexure 44.
page,
Annexure, no, page 16, page 44, annexure 16, my lord.
accordingly. Pursuant to the advertisement dated 31st May 2017. Petitioner met her application for provincialization of her services. When was this made?
5/6/2017.
On 5/6/2017. Stop. However, as the case of the petitioner is yet to be considered for provincialization of his services, of her services. Stop. Follow. In that view of the matter, present petition is disposed of, directing the respondent authorities, particularly the respondent number 3.
Director of Elementary Education.
Respondent number 4. Respondent number 4, the director of the director of elementary education Assam, to consider the claim of the petitioner for provincialization of her services in terms of the Act of 2017. Stop.
Upon due verification.
Huh?
Upon due verification.
After due verification of all relevant documents. Stop. After considering the case of the petitioner, if the petitioner is found to be eligible for provincialization under the Act of 2017, steps to taken to give the benefit of provincialization to the petitioner at the earliest, but not later than
3 months, my lord.
3 months from the date of receipt of a copy of the order of this court. Stop. With the above provisions and directions with petition.
Yeah. Must be this.
7.
May it please, your lordship. Lordship, I'm in instruction. Kindly peruse the order 16-5.
16/5.
Instruction was sought for from my friend.
Lordship, today I have received the report and affidavit is on the process of filing, Lordship. Lordship may take it up on Friday, Lordship.
When are you filing your affidavit?
Lordship, 2 days, just 1 day time, Lordship. May take it up on Friday or
That will
Monday,
take
Lordship.
time to come on record.
Yes, Lordship.
I'll give you a week's time. But Mr. M.R. Khandagar, Learning Council. Mr. B. Chowdhury, the Standing Council,
SSA.
SSA submits that he has received the records. And affidavit in opposition is being prepared and will be filed within a short period of time. Stop. Accordingly, list is better. After 1 week.
It may be on 20, my lord. 20. A small issue, my lord. Your lord.
We'll have it on 22nd.
20.
Okay.
I am okay.
8. Item 8, Lordship, I need some time to file my affidavit letter also to receive instruction. Let it come after vacation, in I'll file my affidavit. I have already informed the board the side, Lordship.
Lordship. You are Mr.
M. Mondal, Lordship.
Third M. Mandal and Mr. S.M.D. Chisti, Understanding Council.
Secondary education.
Secondary Education, praise for 3 weeks time, people counter. Yes. Praise a lot. Mr. Matter.
On date may be fixed, madam.
Did it come up to the?
I'm paying for a sort of 4, my lord.
There is the matter up to the summer vacation. Mr.
Yes.
Yes.
We have filed out affidavit also, madam.
S. Mukhtar, Learned Council, appears for respondent. 4.
Oblige you.
9, 10, and 11.
Please, your lordship. Lordship, in these matters, my lord, senior advocate Diganta Das will appear, my lord. One matter is going on. May I appear? This matter may be taken by 2, my lord.
It's 2.
My lord.
What's it?
Oblige, sir.
Twelve, 13, and 14 order.
Lordship, the matter may be passed over for timing, Mr. Senior, isn't it?
Why is it coming up for orders?
Lordship, on the last occasion, it has come for admission only, Lordship.
Yeah.
Yeah, on the last occasion, it came for in the admission column. And due last 2-3 occasions, due to paucity of time, the matter couldn't reach. So, Lordship, may kindly hear my senior on this in the matter, Lord.
Where is your senior?
He's on legs, Lord. Lordship. So he's coming.
Sixteen. Hearing. Hearing. 16.
So for time being, my senior is coming, Lordship. For time being, Lordship. My senior
What
is
is
coming.
the problem?
It's like another course, Lordship. He's coming just.
Seventeen.
It's also nobody there.
Seventeen.
None appears for the petitioner. Anybody appearing for higher education?
Although this is so, I say elementary matter.
Elementary in the possibility shown as higher, that is what it's elementary, Lordship. My friend, yes, will appear.
Mr.
And Fukon will appear, Lordship, for elementary.
N. Fukan,
Yes.
Mr. MS. N. Fukan,
role like Dubai
appears for the elementary education. List after the summer.
Only in the possibility, Lordship, the standing consider elementary that may be shown.
Registry is also directed to reflect the name of the standing council for elementary
Elementary.
education. in process.
Oblige your Lordship.
12, 13, and 14 order.
May it please your lordship. Well, subject to your lordship's convenience, well, it's a small matter, but it can be disposed of. I'm ready if your lordship permits me to argue for disposal.
Who are the other sides?
But health department is there. They have already filed their response.
Health department,
It's a promotional matter, my lord. Promotion has been given during the pendency of the writ petition, but the promotion has not been given from the retrospective effect from the date when it was due, because it was not due to fault of mine that the promotion was not given. It is only after filing of the writ petition when we pointed out that the this is the property, that the annual property return and all. It is the duty of the principal to forward it. He forwarded it late. So when the DPC was sitting, it did not have the 1 year property list. So that's why it was denied. But now from the gradation list and all, it can be seen that I am senior because the post is seniority come merit. So only in this case, I have to be given the
notionally the benefit from when my juniors were promoted and when my promotion was due. That's the only issue remain, my lord.
What are you appearing for?
I'm appearing for the health department, my lord. I have filed affidavit, my lord.
You ready?
Yes, my lord.
They have not objected to my granting of the notional promotion from the date when my juniors were promoted, my lord. Their affidavit doesn't object to it. They have only placed the facts how this has happened, my lord. I have now only that notional benefit and the consequential benefits that has to be granted. Your lordship will kindly see first the notification. Your lordship will kindly take up the WPC number 5231 of 2020, item number 12, WPC number 5231. Your lordship will kindly see the first annexure 7 at page 58, where the respondent number 5 was promoted, my lord.
Yes.
Just a moment. Your lordship will find at the bottom, my lord, at the bottom, Bhaskar Das, page 59. He is respondent number 7, my lord. Respondent number 5, sorry.
Page 59.
Page 59, bottom, my lord. He is Bhaskar Das, my lord. He is respondent number 5. Your lordship will kindly note only that he has registered dentistry, Jorhat Medical Hospital, is on promotion, posted as assistant professor. This promotion was granted on 1/11/2019. Then your lordship will find the respondent number 6 and 7 were also promoted, my lord. That is, your lordship will find at page 66. Annexure 10, my lord.
Respondent?
Respondent number 6 and 7, my lord. Rajashree Bora, respondent number 6, my lord. And Dr. Ornima Goswami is respondent number 7. They have been promoted on 31st of December 29. Then your lordship will kindly take note of the gradation list, my lord. I'll just place the brief facts, my lord. Gradation list at page 68, my lord.
Yes.
Your lordship will find that serial number 12 is the petitioner, my lord. Bhaskar Das is respondent number 5. Rajashree is respondent number 6. Ornima is respondent number 7. And your lordship will find the date of joining, my lord. Date of joining, your lordship will find first, second, third, fourth, fifth column, 19/3/2015 of the petitioner, my lord, at page 68. Again, serial number 12, 19/3/2015 is the date of joining. Then Bhaskar Das is 2016. Rajashree is 2/5/2016. And Ornima is 15/3/2017. Then now your lordship will find then your lordship will find the minutes of the DPC, that is at page 69, but the relevant portion your lordship will find at page 72, my first DPC. Your lordship got it, page 72.
Yes.
Page 72, my lord, your lordship will find assistant professor. Dr. Alpana Talukdar, UR, would have been eligible but for non-submission of ACR for the year 2016 as per record of DME.
One assistant professor,
Yes, my lord. Then Dr. Alpana Talukdar, my lord, who is the petitioner, my lord.
dentistry.
Assistant professor, my lord. Dr. Alpana Talukdar, my lord, page 72. Dr. Alpana Talukdar, UR, would have been eligible but for non-submission of ACR for the year 2016 as per record of DME. The next senior most eligible incumbent, Bhaskar Das, Rajashree Bora, and Ornima Goswami may be promoted to the shop. Just because, my lord, at that time I was serving in Tezpur Medical College. My lord, the principal forwarded it lately, my lord. That's why I was not promoted. When I filed this writ petition, they promoted me in 2020, my lord. I'll come to that, my lord. Now your lordship will kindly see page, the next page is at, my lord, page 76, my lord. Now at page 76, my lord, your lordship will find the annual property return statement was forwarded on 17/8/2019, my lord. Your lordship will find. With reference to the subject, I have the honor to submit herewith the annual property return for the year 2018 of 20 faculties of so and so, so and so, so and so. Now, next page at page 77, your lordship will find my name. Serial number 7, my lord. Minus 200. Now your lordship will kindly see this letter is dated 17/8/2019. This page 76. Page 76. And the minutes is dated, my lord, 30/8/2019.
Which minutes?
Minutes that I have referred why I was not granted, my lord, that at page annexure 12 at page 70. Page 69.
Yes.
This is dated, my lord. Your lordship will find. This minutes is dated 30/8/2019. Yet to go. Held on 30/8/2019 on the third line at the top. So this was 30/8/2019 because why I have not been granted the promotion because my ACF for the year 2016 was not granted. But they have forwarded this property at page 77. This was forwarded prior to it. Now your lordship will see the next annexure. Huh? 15. Page 15, my lord. This was given, my lord, 17 September 2020. I was promoted subsequently after filing of the first writ petition, my lord. This is the writ petition which was filed, my lord, because my juniors and all were not there, encompassing all everything. We had filed it after our promotion was given because in the earlier writ petition that notional promotion was not there. We had directly challenged the promotion of those respondents who were junior to us. So this was given on 17 December 2020, but it was not given retrospective effect from the day when my juniors were promoted. Now your lordship will kindly look into the additional affidavit which was filed on 1/12/2022, where I have enclosed the gradation list, the fresh gradation list.
Yes.
Now your lordship will find the additional affidavit at page 87. Your lordship got the broadsheet.
Yes.
Now your lordship will find at serial number 929 is respondent number 5, page 87. 10 is my lord respondent number 6. Ornima Goswami is respondent number 7. Alpana Talukdar is the petitioner, my lord. R5, R6, R7, and petitioner. Now Now for the next post of associate professor, my lord, if the notionally I am not counted from the day when my juniors are promoted, then I will not be eligible for the associate professor before them because they will have 1 year ahead of me as a seniority because it requires 4 years of experience. That's why your lordship will find against the assistant professor date of promotion, your lordship will find 31st December 29, 31st December 2099. In case of me, it is 17th December 2020. They have not filed the affidavit in this case, my lord. In one other case, the health department has filed, but it has comprehensively include everything, my lord. Your lordship will find it that in the WBC number 8292 of 2019, the affidavit of the health department. No reply today. Item number 14, my lord.
Respondent one.
Yes, my lord. Now your lordship will see what is the contention at paragraph number 6, my lord. Now your lordship, I'll just read, my lord. It's a brief paragraph, my lord. That as regards the statement made in paragraph number 7, 8, and 9 of the petition, your deponent states that the belated submission of ACRs and APRs of the petitioner by the respondent number 4 towards consideration of her case by the DPC for her promotion is not disputed. The Departmental Promotion Committee held on 30/8/2019 did not recommend the petitioner for the promotion to the post of professor as her ACR for the year 2016 was not submitted as per record of the Director of Medical Education, Assam. The recommendation as contained in the minutes of the DPC dated 30 was considered by the government in the case of the petitioner as well as a potential were duly considered by the government. On such consideration, it was found that although the ACR of the petitioner for the year 2016 was not available for the year 2000 was not available for consideration for the purpose of granting promotion. Moreover, it is very pertinent that although the APR of the petitioner for the year 2018 was submitted, the same was submitted by the petitioner before the respondent numbers 4 on 5/8/2019 belatedly, whereas the same should have been submitted within 31st January 2019. The APR statement of the petitioner along with other doctors of the Tezpur Medical Colleges were forwarded by the respondent number 4 to the respondent number 3. Why this forwarding letter dated 17/8/2019? Malad, this contention was never reflected in the minutes which I had just referred at page 72 of the petition. Malad, the why my promotion was not considered, Malad, your lordship will, I will just read the line again. Minutes two. Minutes two. Page 7, your lordship will find again that in this affidavit also they have enclosed. Your lordship will again look at page 7. Why it was not considered, my lord. Page 7 of this affidavit also.
Yes.
Page 7, the assistant professor, Dr. Alpana Talukdar, UR would have been eligible, but for non-submission of ACR for the year 2016 as per record of DME. So this non-submission of APR was not a relevant factor before the minutes, before the DPC. It is only an afterthought, my lord. This has been included in the affidavit, my lord. Now your lordship will see, even in their own statement at page 12 of that affidavit, your lordship will kindly see.
Page 12.
Of the same affidavit, just which I have referred, my lord. This is WPC number 8292.
Page?
Page 12, my lord.
12.
12. The property return, which is their format, my lord, has been submitted and it has says yes. This was submitted on 14/8/2019 and prior to holding of the DPC. And it says that the annual property report return of that year was there. This was annual property return was never a consideration before the DPC, my lord. So this APR is just an afterthought, my lord, just to cover up their own lapses, my lord. And in regard to paragraph number 6, my lord, I have filed an affidavit in reply. Your lordship will find it was filed on 23/11/2020.
Yes.
Affidavit in reply, your lordship will kindly take note my reply to that paragraph number 6 at paragraph 5 at page 2. Your lordship got it, my lord?
Yeah.
That with regard to the statement made in paragraph 6 of the counter, the deponent begs to reiterate and reaffirm all the statement and averments made in the writ petition and denies whatever statements and averments made in the counter which are contrary thereto. Further, the deponent begs to state that the promotion of the deponent was not taken into consideration due to the belated submission of the ACR for the year 2016 by the respondent number 4. The APRs of the deponent for the relevant years were submitted before the DPC, which were held on 30/8/2019. The contention raised in regard to late submission of APR in terms of the office memorandum dated 5/2/2014 is an afterthought to cover up the lapses and negligence of the departmental authorities. Nowhere in the minutes of the DPC and the records it is reflected that due to late submission of APR of the deponent, her case was not considered for promotion. It is pertinent to state herein that it was only by letter dated 30/4/2019 the ACR and APR particulars of the deponent and other faculty members were sought for on or before 2/5/2019 for scrutiny and submission to the government by 3rd May 2019. Accordingly, on 1/5/2019, the deponent submitted her APR particulars to TMCs. The process is once the APR particulars are submitted by the deponent, it is the responsibility of the authority of, this is Tezpur Medical College Hospital, TMCHS, to forward it to the concerned department. Prior to it, there was no official communication to the deponent to submit her APR of that particular year to the authorities. Once again, on 31/7/2019, a letter was reissued by the DME requesting for submission of APR particulars of the deponent and other faculty members, which the deponent submitted in the office of the DME on 5/8/2019. Thereafter, again on a telephone instruction from the office of the DME, the deponent resubmitted her APR particulars on 1/11/2019. It is categorically stated herein that the belated submission of the APR of the deponent was never a hurdle for non-consideration of a promotion, as all APRs of the concerned years were before the DPC, which is clearly reflected in the minutes and the statement prepared for assessing the competitive merit of each of the candidates for promotion. So this is my reply to that. Basically, this is the contention of this. Now your lordship will only see what I am seeking at the moment is the prayer in WPC number 5231 of 2022. My prayer is at that writ petition 5231, item number 12. My lord, prayer is at page 20.
Yes.
My lord, first prayer is to direct the respondent office to grant retrospective effect to the promotion given to the petitioner to the post of rank of assistant professor of dentistry, so and so, and to make her said promotion effective from 1/11/2019. That is the date on which her immediate junior, respondent number 5 was promoted, and to place the petitioner above respondent number 5, 6, and 7 in seniority in the rank of assistant professor of dentistry, and to give her all other service benefits. To direct the respondent to take into consideration the claim of the petitioner for promotion to the next higher post of assistant professor of dentistry and place the petitioner above respondent number 5, 6, and 7. So basically, my lord, now this AC non-submission of the ACR for particular year, it is your own authority. It is the petitioner doesn't have control over the ACRs. And APR, yeah, I have already shown your lordship that this was never a consideration before the DPSC that the APR of certain years and all were not there. So only today that the balm that can be given to the injuries which the petitioner has sustained all these years is that since my date of joining is earlier to them, and due to non-submission of the ACR of that particular year by the principal of the Tezpur Medical College, my lord, I cannot be faulted for it, my lord. So that is my humble submission before your lordship. I'm not asking that that they will pay me the salary and all. Only I'm asking that I should be placed above notionally above my juniors, so that even in the next post when the consideration will come for the next higher post for promotion, I'll be below them because they will otherwise not fit my experience. They will have 1 year ahead experience of me. So 4 years is required, then I will be all along my life, although I have joined early, I'll face discrimination, my lord. That's my humble submission before your lordship for consideration, my lord.
May I please the lordship, my lord? The case of the petitioner, my lord.
Bora will take up it.
Yes, my lord.
Already continued. Basically, issue is very simple.
Yes,
Yes, my lord.
DPC
Issue is simple, and there is one office memorandum also, my lord. I will place it, my lord.
DPC minus indicates.
My lord,
non-submission of
DPC,
issue.
the duty of the DPC is to recommend. So the appointing or promoting authority is government. So government has to consider all the aspects, my lord. Because there is a office memorandum of the personnel department which says that, my lord, APR has to be submitted within January of the concern year. That means she had to submit the APR within January 2019. Only in that case, the case will be considered for promotion. But she did not submit, and that's why the government did not consider, my lord. DPC, my lord, DPC will recommend only, and government will consider all the aspects, my lord. And thereafter only the government can make the promotion, my lord.
My lord, they have not put me into the zone of consideration. DPC has only not recommended. Where is the question of consideration by the government, my lord? He is talking about the next step. I leave you to the wisdom of this one. Stipulates that the annual property returns had to be submitted.
What is the affidavit?
Affidavit of the respondent number 1, which was filed on 7/10/2020. Just I had referred, my lord, that affidavit where in 8292, in WBC number 8292, my lord.
Yeah.
Now, your lordship will kindly see that office memorandum which makes it stipulates that annual property return has to be submitted is at page 16. Now, your lordship will see dated dispute the 5th of February 2014. This is an office memorandum. And it has been laid in clause 2 that it has been therefore decided that all officers of government of Assam shall submit the annual property returns in 2 separate forms, immovable property return, movable property return, by 31st of January every year to the respective appointing authority or disciplinary authority, copies of the 2 formats. Then who did not submit the annual property returns in time would be denied vigilance clearance and will not be considered for promotion, employment for senior level post under the government deputation to foreign services, permission for foreign tour permission, so and so, so and so. So these are the 2 relevant clauses. So far, this 5th February 2014 memorandum is concerned. Now, so far our case is concerned, your lordship will again look into what is our contention. That this annual property return was never asked by the TMC. Whenever the Tezpur Medical College authorities have asked for this annual property returns, I have submitted. And all my annual property returns with the particulars which are required were submitted before the consideration of the DPC, my lord. Your lordship will kindly see my affidavit in reply, my lord. I have given, my lord, that your lordship will find the affidavit in reply filed in 8292 of 2019, which I had referred earlier, my lord. That paragraph number 5, my lord. Now your lordship will see the in page number 3, the first line. My lord, your lordship will take note of the date of DPC is 30/8/2019. It's of 30th of August 2019, my lord. It is pertinent to state here that it was only by letter dated 3/4/2019 that I have annexed in this affidavit in reply at page number 5, my lord. So this date is prior to holding of the DPC. It is pertinent to state herein that it was only by letter dated 30/4/2019 the ACR and APR particulars of the deponents and other faculty members were sought for on or before 2/5/2019 for scrutiny and submission to the government by 3rd May 2019. Accordingly, on 1/5/2019, that is in May, and the DPC was held in August. Accordingly, on 1/5/2019, the deponent submitted her APR particulars to TMCH. The process is once the APR particulars are submitted by the deponent, it is the responsibility of the authority of TMCH to forward it to the concerned department. Prior to it, there was no official communication to the deponent to submit her APR particular of that particular year to the authorities. Once again, on 31/7/2019, that is also prior to the holding of the DPC. A letter was reissued by the DME requesting for submission of APR particulars of deponent and other faculty members, which the deponent submitted in the office of the DME on 5/8/2019. Thereafter, again on a telephone instruction from the office of the DME, the deponent resubmitted her APR particulars on 1/11/2019. It is categorically stated herein that the belated submission of the APR of the deponent was never a hurdle for non-consideration of promotion, as well as all the APRs of the concerned years were before the DPC, which is clearly reflected in the minutes and statement prepared by the assessing the competitive merit of each of the candidates for promotion. Now, in the minutes of the selection proceeding, I have already drawn my lordship's attention that this non-submission of APR was not a consideration for them, my lord. And in regard to this office memorandum, my lord, there is a division bench of the judgment of this honorable court. Your lordship will kindly look into where this office memorandum was taken into consideration, my lord. It is reported in 2020 GLT 363, my lord. State of Assam versus Bharat Bhushan Raskwa. Your lordship will kindly look at paragraph number 5 first. Paragraph 5. A perusal of the order goes to show that the case of the writ petitioner was not considered on the ground that the writ petitioner had failed to submit annual property return statement within the stipulated period, which is mandatory requirement for promotion of class 1 rank officers as per office memorandum or the personnel department, Government of Assam, dated 5/2/2014. Then your lordship will look at paragraph 8. While the office memorandum dated 5/2/2014 is on the subject of submission of annual property return statement by class 1 officers of the Government of Assam, clause 2 of the said memorandum requires all officers to submit the annual property returns in the prescribed format. The state government may take appropriate action in this regard to remove the apparent ambiguity. Then your lordship will look at paragraph number 9, the last 4 lines. No document has been placed even in this writ appeal indicating that despite asking from the property return statement from the petitioner, the same was not furnished by the writ petitioner. On the contrary, on 3/5/2000, only the ACS were forwarded in respect of 9%, wherein the name of the writ petitioner figured at serial number 1 being the senior grade junior engineer. In the attending facts and circumstances of the case, it cannot be said that the petitioner had deliberately not submitted the property return statement, and it was result of the improper communication of the requirement of the superior authorities. So, my lord, here also nothing has been placed on record to show that the APR was sought by the departmental authorities and it was not given, my lord. Whenever the authorities have sought for that APR, we have submitted it before the concerned authorities. Now, because of the interdepartmental, I don't know what is there. But on record, my lord, this property statements were there before the authorities, because again in that, if your lordship will recall that checklist, it was marked as yes. So it was already there before the authorities, my lord. Now your lordship will see it. So far this post of promotion is concerned, just like in that engineering service role, here also, so far the rules of promotions are concerned, this submission of APR is not a mandatory requirement to grant me that promotion, my lord. This I'll just refer to that. This is, my lord, Assam Medical Education Service Rule 2008. Well, it's only, your lordship will take note, it is Rule 13E. Rule 13E of the Assam Medical Education Service Rule 2008. And it simply says, my lord, promotion to the higher post shall be on seniority cum merit basis. So this process, this post which I am talking and which the rule is applicable, it is seniority cum merit. Under this service rule, it has not been made mandatory that APR has been to be made is mandatory requirement for promotion. Although they have said in the office memorandum, your lordship has seen the intent and of the judgment of the honorable division bench that these are requirements, my lord, which are suppose due to some officers have not given you. If you showed that you have asked for me and I have not given, then it's different, my lord. Whenever the authorities have asked for it, my lord, I have given it, my lord. Rule 13E. of the Assam Medical Service Rules, my lord.
2000.
My lord, just one, 2008, my lord. এই ডিপিসিত যে আমাৰ মাৰ্ক কৰি থৈছে প্ৰপাৰ্টি ৰিটাৰ্ণ টু ইয়েছ বুলি আছে এইটো ক'ত আছিল?
Bora, you have the records?
Yes, my lord, I'll place only one more judgment, my lord. Your lordship will again see this affidavit of respondent number 1, my lord, filed on 8292, my lord.
Respondent number?
Respondent number, my lord, 1, my lord, filed on 8292, my lord. That is the composite affidavit filed by the authorities. Page 12, your lordship will find annual property return submitted for the years ending 2000, yes or no? Yes.
Issue is that the DPC, while considering the case of the petitioner, did not recommend the petitioner's name
Yes, my lord.
only on the ground that the ACR was none,
Yes, my lord.
not the APR.
Not the APR, but subsequently, my lord.
Obviously, the APR was before the DBC.
No,
Because
my lord.
the petitioner had
no,
already
no.
submitted his
What has
APR.
happened, my lord? After that, the petitioner approached the government, my lord. Then government considered all the aspects, my lord. Then they considered the ACR and APR. So while examining the APR of the petitioner, they found that was in violation of this office memorandum issued by the personnel department, my lord. Because DPC will make the recommendation only.
Unless the DBC makes the recommendation,
Yes,
how
my
will
lord.
the government consider?
No, if
Unless recommendation is made, how will the government consider?
government will not consider.
Exactly, that's what
But
I'm
the
asking you. the
petitioner
question.
approached the government with the contention that because ACR was not submitted, not due to the fault on the part of the petitioner, my lord. So that was her contention before the government, my lord. So she approached the government praying for promotion, my lord. Then government, my lord, looked into this aspect, my lord. Whether assuming that ACR, it was the duty of the concerned authorities to submit. That was not submitted within the stipulated time. And the ACR was not before the DPC. Then also, my lord, government could have considered her case, my lord. Because, my lord, if APR was in terms of this office memorandum, because it is apparently in violation of this office memorandum. Your lordship, kindly see the APR submitted by the petitioner, my lord, at page 13
Of your,
of my affidavit, 13 and 14, my lord.
yes.
So in this APR, my lord, the date is 5/4/2019. 5/8/2019. So she has submitted, my lord. So down below the date is there, my lord. Page number 13 and 14, my lord. 5/8/2019. So she submitted the APR on 5/8/2019, and this APR is for the statement of immovable property for the calendar year ending 2018, my lord. And what the office memorandum says, my lord, it has also been decided that Office of Government of Assam who do not submit the annual property return statements in time would be denied vigilance clearance and will not be considered for promotion. Clause 2. And clause 1 says that it has been therefore decided that all officers of Government of Assam shall submit their annual property returns in 2 separate forms, namely immovable property return and another for movable property return, henceforth regularly latest by 31st January every year. So the APR of the 2018, she had to submit within January 2019. So in that case, her case would have been considered for promotion in the minutes which was held in the year 2019. So she could not submit, my lord. So that was in violation of this office memorandum, and the authorities, the government, my lord, cannot go beyond this office memorandum, my lord.
What does the rule say?
Which rule, my lord?
The Assam This rule,
Assam Medical Service,
medical education service rule.
2008.
That is the 31st January. Yeah. Rule also says the same thing, my lord.
Where is it?
The Assam Services Mineral, my lord. Assam Civil Services Conduct Rules 1965, my
No,
lord.
no, I'm on Assam Medical Education Service rule.
That is, my lord, that is merit, seniority come.
Merit basis.
It is a different aspect. But if she doesn't fulfill the eligibility criteria, my lord, APR is not there, my lord, in terms of the office memorandum, then how she can be promoted, my lord? Subsequently, my lord, because there was no any other reason for denying promotion, because in the subsequent DPC, she has been promoted, my lord.
Subsequent.
Because it was-
We're talking about the first DPC.
It
We're
was-
talking about the first
Yeah,
DPC.
it was her ignorance, my lord. She did not submit the IPR.
According to the petitioner, she had submitted her APR. ACR was submitted late, not because of the petitioner's fault, but it's because of the fault of the college in which she
No,
was serving.
APR, it was purely on the part of it is the responsibility of the concerned officer, APR.
DPC did not mention APR. This is the issue I'm asking you.
The DPC, she approached the government that the ACR was.
One thing, we're having a misconnection.
My lord, if you,
First thing is the
No, no.
DPC will consider all the eligible candidates
yes, my lord.
and make its recommendation for promotion.
If your lordship peruse annexure 1, page 4 of my affidavit, my lord. So there is also, my lord, page 4, my lord.
Yes.
The down below, point number 2, my lord, the committee considered the following criteria for promotion. Eligibility. Service tenure, teaching experience as per MCI norms, requisite number of research publications, ACR in last 3 years, IPR for 2018. IPR or APR, my lord.
What is IPR?
Immovable property returns, my lord.
This same, my lord.
Same, my lord. So that was also considered, my lord. But somehow, my lord, that was not reflected in the minutes, but the government considered that aspect, my lord.
My 2018 IPR was before the
My lord,
committee.
assuming that, my lord, that there was some mistake on the recommendation of the DPC, my lord. But how she can be promoted in violation of this office memorandum, my lord? Apparently, my lord, she did not submit the APR, my lord.
This is the issue.
Yes, my lord.
The minutes clearly indicate that they have considered ACR,
Yes, my lord.
IPR
Yes, my lord.
of the concerned candidate.
Candidate.
Now, when the recording of the recommendation came, so
Yes,
far
my
as the petitioner is concerned,
Yes, my lord.
they have omitted IPR. That means IPR was before the DPC.
No, my lord.
Show us the record.
I can show, my lord, it was before the DPC, but it was not within in terms of the office memorandum of the personnel department, my lord. Because it was
IPR was before the DPC.
yes,
correct?
my lord. Yes, my
That's
lord.
it.
No, my lord, it was not in terms of the office memorandum. It was submitted on 5/8/2019 only. Whereas it should have been submitted before January 2019, my lord.
That part is one issue.
Yes, my lord. That is the main issue, my lord. The core issue is that
Because DPC did not mention IPR or APR.
there may be some omission on the part of the recommendation of the DPC there.
No. Let us not submit like this.
Yes, my lord. But my lord, your
DPC
lordship just examine that, examine whether she was eligible for promotion in terms of this office memorandum or not. Because as per record, she has submitted the APR on 5/8/2019, which she should have been submitted within January 2019. So your lordship just examine that issue.
Other candidates, they submitted on
Yes,
time?
my lord. Yes, my lord.
Where's the IPR?
For
Well,
2019, my lord.
That record, entire records I have not obtained, but
Get the records, I'll see.
yes, my lord, I can get the
Let us see
record.
whether the other candidates,
Yes, my lord.
whether they submitted the IPR on time or not.
Yes, my lord. That I can obtain. And other candidates, they submitted in due time. That's why they have been considered. I will obtain. I can obtain the records, my lord.
Because rejection of the petitioner by the DPC
Yes, my lord.
non-recommendation, let us not say rejection,
Yes, sir.
non-recommendation of the petitioner by the DPC
Yes, sir.
was only on one ground,
Only.
that there was no ACR.
But now, my lord, the record is before
This
your
court has
lordship.
to go on the basis of records.
Yes, ma'am.
Yes, my lord, because record is before your lordship. Your lordship can examine whether, my lord, the conditions stipulated in the office memorandum that has been fulfilled by the petitioner order.
That we'll see, but we'll see whether the other candidates also
Yes,
have
my lord.
fulfilled it.
Yes, my lord.
My lord, your lordship will kindly take note. In the minutes, it is said that IPR for 2018.
Correct.
It is there. Then how the other candidates will know that the IPR of the other years will be looked into by the committee, my lord. The committees, they have
No,
made their
only-
own. This minutes is not under challenge by the private respondents. This, my appointment is not under challenge by the private respondents. They are only here to defend their own promotion. But then the IPR for 2018 is there, and it clearly says in the that Alpana Talukdar would have been eligible, but for non-submission of ACR for the year 2016 as per record of DMA. Now he says, without even recommendation by the DME, by the DPC, we have taken into consideration all the facts, including APRs and all, then we find that she is not suitable in terms of that. That is not the, that is not
I
the
can get the
issue before the, just,
I can get
that
the
is not the
records
issue.
to show that
And-
the other candidates have submitted.
and you will also will see, you will also kindly look into the judgment in terms of the rules, my lord, what is required to be seen, my lord. Ekon note koi lakhe. It's Manu stroke SC 2738 2006. Horogobind Yadav versus Rewa Siddhi Gramin Bank. Your lordship will look at paragraph 13, but it will be on the next page, Malad, page 6. Page 2. My page in Manupatra is at the bottom, my lord. Your lordship will find at page 6, my lord. Paragraph 13 starts from page 5. Then you'll also look at page 6. My lord, you'll also will. My lord, in Sanram Sharma versus State of Rajasthan, this court has pointed out that the principle of seniority ensures absolute objectivity by requiring all promotions to be made entirely on grounds of seniority, and that if a post falls vacant, it is to be filled up by the person who has served longest in the post immediately below. But the seniority system is so objective that it fails to take any account of personal merit. It is fair to every official except the best one. An official has nothing to win or lose provided he does not actually become so inefficient that disciplinary action has to be taken against him. The criterion of merit, on the other hand, lays stress on meritorious performance irrespective of seniority, and even a person though junior but much more meritorious than his seniors is selected for promotion. This court has expressed the view that there should be a correct balance between seniority and merit in a proper promotion policy. The criteria of seniority come merit and merit come seniority, which take into account seniority as well as merit, seek to achieve such a balance. The court has also noted that while principle seniority come merit lays greater emphasis on seniority, merit come seniority laid greater emphasis on merit and ability, and seniority plays a less significant role, becoming relevant only when merit is approximately equal. After referring to several decisions bearing on the issue, this court enunciated the following general principle in regard to promotions by seniority come merit at para 18, which is relied on by the appellant. We thus arrive at the conclusion that the criterion of seniority come merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. For assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required and also prescribe the mode of assessment of merit of the employee who is eligible for consideration promotion. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service record and interview, and prescribing the minimum marks which would entitle a person to be merit. So the rule says it is seniority come merit. And whenever you have asked it, I have given it. And the letter that has asked also, that letter talks about my APR only up to on or before 2/5/2019. That letter you also will find. DPC was held on 30/8/2019. That letter I have annexed at in my affidavit in reply of WBC 8292. It asks for the details of my APR that at page 6 your lordship will kindly look into the affidavit in reply filed on 8292. Now your lordship will see the document number 6, my lord.
Yes.
Page 6, my lord, this was given on 30/4/2019 and DPC was held on 30/8/2019. This was written to the head in charge, Tezpur Medical College by the principal come. Now your lordship will see on or before 2/5/2019. So my API will be of 2018 only. 2019 will not be there. So I have submitted that API of 2018 and that has been taken into record by the DPC. So how can he place the cart before the horse? What he is telling the government, my lord, to come for a writ of certiorari, always the court will ask that whether you have given a representation or not. Without giving a representation, your lordship may not encourage. So sometimes when the employee given, that doesn't mean that in spite of the DPC not recommending, you come with a stand that we have taken into consideration all the factors, and since you have not submitted the API, my lord, that's my humble
My
prayer.
lord, I will obtain the records, my lord.
When?
It is a old matter, it will take some time, my lord.
After vacation?
Yes, my lord.
Well, your lordship will fix a date because otherwise the next promotion is due.
It is convert the senior counsel. Assisted by
Mr. Harshit Agarwal. H. Agarwal.
H. Agarwal, then completed. Mr. D.B. Boral, then the standing counsel, medical health, health department
Yes, my lord.
shall produce the records with regard to the departmental promotion committee, which held its meeting on 30/8/2019 by the next date. When do you want?
Well, any date before the vacation because he has only to bring the record. Hearing is a more or less complete, my lord.
It is after vacation, my lord, because 2019 records, my lord.
My lord, it's a promotion old matter. And only I am already 1 year junior. The others
he
will
has
now,
been promoted.
because of 4 years, my lord, they have been promoted in 2019. Those 4 years will be over in 2020. If they promote it, then again I have to file a separate writ petition challenging on the same cause. my lord.
Now he has been promoted, my lord.
Actually, he has to have it ready with the DPC's record, my lord. It's unfortunate, my lord.
18 July.
Yes, my lord. My lord, hard in part, my lord, because I have concluded my hearing, my lord.
13.
Deeply obliged. my lord. I'm obliged. my lord.
Can it be on 28th of July? I am representing the private respondent number 5. My lord, on 18th, some difficulty with.
Well, I have no objection. Your lordship may accommodate.
With all respect, my lord. Just
Your lordship may accommodate him. I have no.
When do you want?
20, my lord. Just 2 days.
20.
I'm so obliged. I'm sorry.
May I take your lordship indulgence to mention item number 17, my lord.
Yes.
But the matter was, my lord, very urgent from the client's point of view, my lord. Therefore, it was fixed for hearing. The college teachers, my lord. Somehow, my lord, I could not be present when the matter was called. It has been referred to some other day. If your lordship can hear the matter today itself, or my lord, any other short
I
order.
think I've already signed the order. I signed it. Huh?
The other day, lordship has almost heard the matter. man.
I've already signed the order.
Please sign.
What do we do? Huh? Oh, it's signed and uploaded.
Can be fixed on Tuesday next month, 20th. As submission in the letter.
Can you delete it? Huh? Huh? Doctor. Okay, wait for some time.
But I'll inform the other side.
9, 10, and 11 admission.
Third is, your case is the money. 10 to first lesson. 10 to window. Well, you have to pull out 10 more percent. And 9 to songs. Acha. Yes. 9, 10, 11, my lord, is same matter. I could not be present, I was in virtual VC. Honorable Chief Justice Division Bench sitting in Eiselman. I could not. I was present in virtual, that's why I could not be here when the matter was called for me. So my lord, is 9, 10, 11.
And there is one batch is B, Bachelor of Engineering. One batch is under Polytechnic, B Tech, Polytechnic. So different petitioners in 3 different cases. If your lordships kindly pick up.
Can we
case
hear
three.
them together?
Yes, because
Say
they
that,
are,
Your Lordship.
they have filed an
Yes,
affidavit,
yes.
which is, my learned friend says that it covers the case also.
Which case?
Kindly take first item number 9. That was the first case which was filed by us. Subsequently, these 2 number of cases.
Item
Item
10.
10, 10,
10 must be the first case.
10, yes, 2286. Polytechnic, no. So these are all petitioner before lordships, Polytechnic.
These are political.
Yes, Polytechnic. So they went through a process earlier, my lord, which was advertised by the department. On the basis of the advertisement which was made by the department, there was a test which was held, and accordingly they were selected and they were appointed. And they are treated as a guest lecturer in different places, different district, in different polytechnic. So now, my lord, what has happened? I have been working in the department. While working in the department, at page 22, there was an advertisement for the post on 21/2/2023. Lordship got it? 21/2/2023. Name of post, lecturer technical post in the government polytechnics of Assam. Number of vacant posts is 80. So this is lecturer technical. Now, if your lordship kindly turn to page 23, the qualification is level 9A is BA, B Tech, BS in relevant discipline with first class or equivalent. There are levels. Level 10A is bachelor, master degree in relevant discipline with first class, neither of 2 at the time of application. So these are the qualification of 2 different levels. What qualification required, it has been mentioned. Now, kindly turn to page 24. If your lordship goes down below, process of recruitment. The recruitment process will comprise of Roman 1, OMR MCQ based written examination, 75 mark. Teaching proficiency test is 25 marks. OMR MCQ based question paper booklet shall contain 75 questions carrying 1 mark for each correct answer. There will be negative marking of 0.25, 1/4 marks for wrong answer against each question. Only shortlisted candidate will be called for teaching proficiency test. So what we understand, my understanding is that once you qualify OMR MCQ based written examination, 75, from there it will be shortlisted candidates and they will be called for teaching proficiency test. So now in this case, my lord, will kindly see at page, there was an advertisement, or I have shown that OMR MCQ test we set. Now next will be, they will notify regarding about teaching proficiency test. Now which was notified at page 66. On 23/4/2023. Written test. Written test. OMC, OMR. 24. Is 111. 111. My lord will kindly see at page 111.
Kindly see at page 111. Polytechnic code. Now kindly see schedule of OMR based written test for selection for the post. Date is 30/4/2023. Lordship got it? Post lecture all different. Pragjyotish College, these are the place venue has been given. Different venues and different dates. Kindly see different dates.
Yes.
This we can go on at page 112. So till 7/5/2023. Lordship got it? Now at page 66. Now what they have done when this test was given at page 66 prior to that on 23/4/2023, which were aggrieved, they have issued a recruitment notice. Advertisement, which I have addressed to your lordship, is page 22, which is 21/2/2023. The advertisement.
Yeah.
Now that advertisement comprises of two tests. One is OMR MCQ based. Once you qualify it, then teaching proficiency test, which were notified later on at page 66 on 23/4/2023.
Yes. This is the proficiency test.
Yes, teaching skill proficiency test. One thing I'll just place your lordship, that at the time of advertisement, which was issued, I was not aggrieved because there are two parts, OMR MCQ, teaching skill proficiency test. When they came out with this page 66, I was aggrieved. Why I am aggrieved? Kindly see what they have done now. Number one, teaching in continuation of the advertisement, so and so different advertisement, the point mentioned below are to be noted regarding the teaching skill proficiency test. One, teaching skill proficiency test is to be treated as an integral part of the test to be conducted for selection. Thus, the final merit selection list will be based on the gross performance in two tests, OMR MCQ based written test and teaching skill proficiency test. So, my lord, gross performance in these two tests will be counted. One is OMR MCQ as well as teaching skill proficiency test. Absolutely no problem. Next, all aspiring candidates will have to appear in both the tests. So where is the question of all aspiring candidates to appear in both the tests? Lordship has seen OMR MCQ, that's a mark is given, negative mark. From there it will be shortlisted. It is not a case, then the number of candidates will be more. Competition will be, my lord, will be more. So that is the reason why in the advertisement they said OMR MCQ you have to qualify. From there it will be shortlisted. Now here your lordship will kindly see 66. All aspiring candidates have to appear in both the tests. So it's contrary to the advertisement that has been issued. Am I clear to your lordship, my lord? Next, all aspiring candidates appearing OMR MCQ based written test will be now saying will be shortlisted to appear in a innovative written teaching skill proficiency test in a level playing field with no marks on interview. No marks on interview, all written. That's I understand. There is no question of any mark on interview. It's always will be a written. Now next, an innovative written test is designed to assess the relative teaching skill proficiency of all the candidates by using higher order questioning and probing techniques on the following attributes of the candidate as the creative ability to deliver the domain knowledge effectively to target group of students, particularly the beginners. The basic syllabus of the innovative written teaching skill proficiency test will be as follows. These are what this basic syllabus they have mentioned. Ability to articulate and communicate the course of learning objectives in a manner that attract the students with effective examples and appropriate and real life examples. Mala, how they expect this type of test, the ability, once we get experience in our when we are engaged as a direct recruitee, my lord,
then only we'll have that basic training to be sent. And we get the ability of this. My proficiency test, skill proficiency test will be on the basis of later on which I have been trained, sent for training. I'll show that. This syllabus from where they bought, I don't know, my lord. We were under impression, my lord, when this teaching skill proficiency test will be held, it will be as per the AICTE regulation. Maybe they may ask question, a written test on the basis of what I have learned in BTEC, on BTEC. And my past services would be counted. These are not there. Something they have brought very new to us, which is next to impossible for this basic syllabus. Kindly see next, awareness of the candidates about outcome-based education, value-based education, reciprocal relationship of values, domain knowledge, multidisciplinary, holistic education, critical thinking skill, system thinking skill, 21st century skill and skill for sustainability. Now next, ability to organize the lesson plan in a structured manner, depicting the logical sequence and relationship of courses, contents and lesson plans. Ability to connect the previous and future lessons, providing recap of previous lessons. Ability to formulate questions. To measure students' understanding on ongoing lessons. Now all this ability to, all this syllabus has been given, my lord. I have to go through the syllabus and I have to appear for this examination. This is a very new thing to us. I could have very well understood, my lord, that it is on the basis of my past counting, written examination on this teaching skill proficiency test on the basis of what experience I had as a guest lecturer. This is out of course. Can they do it? This is what I am before this honorable court. And this, my lord, will kindly see when you get the skill proficiency test or the innovative written teaching or skill proficiency test only when you occur at page 67. Kindly see. Program calendar 2023-24. National Institute of Technical Teachers Training, Research, Kolkata. Now, if your lordship kindly see 68, technical education vision. To now see, my lord, to introduce emerging scientific technology for development of effective teaching learning system in technical education, to increase the outreach of training by adopting flexible and open learning technology, to integrate the world of work with the technical education system, to assist policy makers, so on. This will go on, my lord. So now, kindly see at page 69. On the about us, National Institute of Technical, I'll read only 4 or 5 paragraphs. Teachers Training Research, Kolkata was established 1967, Technical Teachers Training Institute, Kolkata. This was the first of 4 such institute, other 3 bigs at Chandigarh, Bhopal and Chennai, established by Department of Education, Government of India as fully centrally funded autonomous institution. The primary focus of the institute is to provide in-service training to the teacher and staff of degree and diploma level technical institution and conduct activities related to the quality improvements of the technical education system of the country. NITTR Kolkata has been actively involved in improvement of quality of the technical education system in various states, including those in the Northeast, through innovative academic intervention, providing assistance to policymakers at the national and state level in formulation of educational plan, projects and the implementation in the fast changing scenario. By virtue of working closely over the first few decades, this institute has developed a thorough understanding of the technical education needs to the state in the eastern region, including those in the Northeast. Government of India in 2003 accorded national status to the institute in recognition to the expert services rendered for overall improvement of the quality of the technical education system. NITTR Kolkata acts as a catalyst in introducing changes in various components of technical education system, plays a proactive role in identifying changes in the industry, technology, economic and society, acts as a facilitator in the process of change. So this is what my lord, what they teach us there for training. Now, if your lordship kindly see at page 71, this is what once you get an appointment, direct appointment, these are what have to be filled up. National Institute of Technical Teachers Training and Research, Kolkata. At page 72, kindly see this is a declaration that is the head of the institution has to give it, my lord. Lordship got it?
Yes.
Now next is 74 is National Board of Accreditation. What is the program, my lord? If your lordship now looks into page 66, 66, this syllabus, the basic syllabus, your lordship got it, what I read. First is to ability to articulate and communicate the course objective, learning objective in a manner, attract the students with effective examples, appropriate and real life examples. Lordship will find at page 80. Page 80, kindly see the first vision, mission and program educational objective. 1.1, vision statement typically indicate aspiration and mission statement states the broad approach to achieve aspiration. This is one. Second, my lord, your lordship will find awareness of the candidates of the outcome-based education. That your lordship will find at page 84. 84, 84, 84, kindly see course outcomes and program outcomes. Lordship got it? This is what, my lord, you get trained up. Then whatever syllabus they propose to be given by them, then we can appear. Absolutely no problem. But something which we have not done, we don't have any experience. How can you bring all this equipment notice? From where you got? From where you got this? This syllabus only, this, what we said, these are brought from these courses. This innovative written teaching skill permit is brought from these courses. Now, if your lordship kindly see page 66, to measure students, kindly see 1, 2, 3, 4, 5, ability to connect the previous future lessons and providing recap of previous lesson. Your lordship will find from page 93 onwards. 93, no? This is ability to connect the previous future lesson, provide a recap of previous lesson. Kindly see 93. This is 4.3, academic performance in the first year, academic performance in the second year, academic performance in the final year, page 94. Now, my lord will kindly see next, ability to formulate question to measure student understanding in ongoing lessons. Page 90 kindly be seen, my lord. Page 90. This is your lordship finds students program performance. Lordship got a student performance, page 90. So all this, my lord, if you see next, my lord, to evaluate the performance student maintaining equity, 83 kindly see page 83. 83 C kindly see, my lord. 2.24 C at page 83. Quality of students projects and report writing. 2.24, that is C, process for monitoring and evaluation. Now 2.24C, 2.24C, lordship got it?
Yes.
Now, lordship goes down below, ability to formulate anonymous feedback from student as an opinion about teacher's performance. That your lordship will find at page 82. 82, 2.21. At page 82, teaching learning process. 2.21, Teaching learning process 160. Describe process followed to ensure improved quality of teaching, learning based on following points. E, conduct of experience. G, kindly see, student feedback of teaching learning process, action taken. So these, my lord, will kindly see ability to formulate anonymous feedback from students. So these are the courses one has to go there. I remember my learned friend said these are not mandatory in nature, that you don't have to go for a training. I'll show under the AICT that one has to go for mandatory training. Once you get acquainted with all these courses, absolutely no problem, they can hold this test. But how they are holding this test? What answer I will give it? I don't have an experience. As a guest lecturer, I have an experience to the extent what I have taught, not beyond that. Once I have been appointed, I cannot go for training. A guest lecturer cannot go for training. Once he is directly recruited, once he is promoted, then only he can go for this training. Once you get acquainted with those professors' skill for training, my lord, then of course, absolutely no problem. This syllabus, definitely I'll be able to give an answer to this syllabus. Now, that's why I'm saying, my lord, these are all recruitment notice itself cannot be taken into account because these are only once you get experience. And now, my lord, will kindly see what the AICT regulation says. You start from page 45. Got it, page 45. All India Council for Teaching Technical Education notification. That is 1st of March 2019.
Yes.
Now, this is 1st of March 2019. Now, my lord will kindly see at page 50. Page 50. Kindly see, my lord, 2.22. Counting of first service for direct recruitment and promotion. Lordship got it?
Yes.
Now, kindly see F. The previous appointment was not as a guest lecturer for any duration or ad hoc or in a leave vacancy of less than 1 year duration. Ad hoc or temporary service can be counted provided that period of service was more than 1 year duration. So where is that? My past counting services are not being taken neither in your OMR MCQ base, neither in the test skill proficiency test. So this is totally in violation of the AICT regulation. So where is that my past count service? I worked as a lecturer, guest lecturer. I cannot be equated those who did not work. This is an open competition. Those who did not work, they will also, I worked in that as an AICT as a guest lecturer. Now they violated this provision which has been laid down. Neither your lordship has seen the teaching skill provision test doesn't indicate about my past count services, neither in the OMR. OMR MCQ will not be there. Teaching skill provision test, at least my past count services has to be taken. This is what they have not taken. My lord will now see next page, page 51. 3.0 mandatory teacher training. Every teacher appointed, promoted to any position herein onwards with effect from publication of this gazette shall have to mandatorily undergo 8 online modules of so and so in SWAYAM as per AICT teacher training policy, preferably within first year of service. So these are mandatory. So where is that, my lord? I being a guest lecturer, I was not sent. When I appointed as a direct recruit on a regular basis, then only I'll be sent. So this is what the AICT, you violated all these guidelines. That's why I'm saying they have taken from that. So what my lord, that teacher is not compulsory. It's not that. It is against this what they are saying. My past count services is not being taken. Mandatory teacher training is required, which only once you appoint, then only it will be sent. Then you get equipped with all those syllabus. Now, my lord, I draw your lordship attention. What three orders, one order of this court. My learned friend has filed an affidavit. Kindly see the affidavit first, then I will show the, one second, I'll show that copy of the order. Kindly see the affidavit of the government.
Respondent 4.
Respondent, my lord, 4. So, my lord, my submission before your lordship, 1 is that advertisement, OMR, MCQ is best, 75 mark. On the basis of that, shortlist and thereafter test skill proficiency test. There's a test, teaching skill proficiency test. Now, that was earlier in February 2023. I appeared. Thereafter, I thought that when a recruitment notice will be issued, this is proficiency test, teaching skill proficiency test. Then I thought that my past count services will be counted. Mandatory they have to send, then all the syllabus will come. So I was surprised when they said these are the syllabus. You have to go for written. Now they said also that both the tests cross, absolutely fine. But why they are saying now is not that OMR MCQ base is all has to sit for their exam. There is no question of shortlisting. One hand they are saying no question of shortlisting. One hand saying that no, it's a fair doctrinal level playing we have done. So all has to appear. But these are all contrary to the recruitment notice, which is not supporting in the advertisement they have issued. Number three is my past count services is not being counted. Number 4, mandatorily you have to send for those training. Then you can bring the syllabus. These are my 4 legs of argument. Now I'll show my lord what is their affidavit they have taken this step. At page 115, 114 at paragraph 4. That with regard to the statement made in para 3 of the writ petition, deponent begs to state an advertisement was published by the Assam Engineering Service Recruitment Board for 80 numbers of post of lecturer, technical in the polytechnics under the higher technical education technical department. As per the said advertisement, weightage of 75 marks. Now, my lord will kindly note down. Your lordship has read the advertisement. I have also read the advertisement. Your lordship has not found anywhere the weightage. For the first time, they have brought this weightage. Weightage of 75 marks on OMR MCQ's written examination. 25% weightage of teaching proficiency test is given, and no, there is no provision of interview mark. What do you mean by weightage? What do you mean by weightage of preference? If I am been working in that department, if some new recruitee comes, he will not get the benefit of weightage, which I will get it. That's what I understand. What do you mean by weightage or preferential benefit is given? Preference is given. It is not, you cannot give weightage to all who has not been working. My lord will kindly see this in advertisement. It is not only meant for me who is working. It is meant for who is not working also. Direct recruit. So there cannot be any weightage given to a new recruitee. Weightage is always given to existing employee. So from where they got this weightage of 75 marks? The weightage of 75 marks, if that is the case, then there is no question of those newly recruited. We'll all get the benefits. Very well, they let them say this examination advertisement is not meant for those newly recruited. It is only meant to those existing lecturers. Absolutely no problem. They brought where? It is not a part of the advertisement. Weightage of 75 mark on OMR, 25% weightage of teaching provision is given, and there is no provision for interview mark. The said advertise no way violates the Assam Technical Education Service Rule 1981, AICT Act as claimed by the petitioner. So we are always, Assam Technical Education Service Rule is governed by the under the AICT regulation. I'll show it. Kindly take this, my lord. You'll kindly take this, my lord. Education manual. It was it is by way amended too. Yes, same book. Kindly see at page. It starts from page 741. The Assam Technical Education Service Rule 1981, which the government has referred to it. Lordship is right. They have referred to this Assam Technical Education Service Rule. There is no violation, they said. Now kindly see 741. Now, if your Lordship kindly turn to 747. 747. Academic qualification for direct recruitment. Lordship goes down below, it is substituted. If your Lordship go down, Rule 8 published in so and so in 21/7/2008. Academic qualification for direct recruitment. Academic qualification of candidate for direct shall be as prescribed by governor from time to time. The qualification experience prescribed as on date of the commencement are given in Schedule 2. Now kindly see 8 now or top. Academic qualification for direct recruitment. Minimum academic qualification experience of a candidate for direct recruitment shall be prescribed by AICT from time to time as adopted by Governor of Assam. So this has to be, my lord, prescribed by AICT, and from the time to they have to adopt it. The state has to be adopted, which in Schedule 2. Kindly see Schedule 2, your Lordship will find at page 758. Lordship got it? Yes. 758 Schedule 2. Rule 8, that's which I read, my lord, academic qualification on top. Kindly see 4, assistant professor. Lecturer, lecturer 5, lecturer technical so-and-so, first class master degree in appropriate field, doctorate degree of, or published work of equal standard desirable. Candidate with first class ME degree are not available. Candidate having first class BE degree in the appropriate branch of engineering will be appointed, allowed in so-and-so, so-and-so, so-and-so. So it is always governed by the AICTE regulation, my lord. This academic qualification. So they say there is no violation. Say that in no way violates the Assam technical. Qualification has been laid down. That is in consonance with the that is laid down by the AICTE. Now, kindly see 5, that the statement made in para 4 of the writ petition are stoutly denied, disputed by deponent as experience is not required for the entry-level post as per AICTE notification dated so-and-so annexed to the writ petition. They said that experience is not required for the entry-level post. So entry-level post, here is the lecturer, entry-level post. They said there is no question of any experience into entry-level post. So if that be the case, why you said past count services will be counted as an experience? AICTE, I have shown that. So your statement is wrong. Experience is not required, then my past service will not be counted. You said that we did not violate. If you did not violate in the paragraph 4, you did not violate. How you are saying that paragraph 5, the experience is not required? That's why I'm saying, my lord, my experience working there as a guest lecturer, which they ought to have given my past service, is not been given by them. This is my submission against this para 5. Now kindly see para 6, that the statement made in para 5 of the writ was stoutly denied, disputed by deponent as past experience. Now kindly see, my lord. Past experience is not required for the entry-level post like assistant professor engineering college, lecturer in polytechnic, and senior instruction in engineering college and polytechnic as per AIC notification. This is lordship absolutely violation of AICTE. My past count services you are not taking. How you will not take it? And one end you are saying that I am not violated the Assam technical vis-a-vis the AICTE Act. Violated. That is why I am before this court, my lord. Now, my lord, if my lord, paragraph 5, kindly see once again, that the statement made para 4 of the and disputed dependent as experience is not required for the entry level post, then why you bought the syllabus? If experience is not required, why you bought the syllabus? You bought the syllabus, experience is not required. Don't bring that syllabus if the experience is not required. That's what my submission is, my lord. All this country, what the stand taken by the government, my lord. Now, kindly see para 6. Para 6. 7, kindly see, my lord. That with regard statement made in para 6 of writ petition, deponent begs to state, as per initial advertisement, teaching provisional test is an integral part of selection process. And as such, the merit test is to be based on gross performance of the two tests, OMR MCQ based written test or proficiency test, to sustain equity among all appeared candidates with the basic declared principle of 75%, 25% weightage in the OMR based written test and teaching provisional test respectively, with no declaration of result of the first phase OMR MCQ based. How it can be, my lord? Kindly see, respectively, no declaration of result of the first phase OMR MCQ based written test before the teaching provisional test. Lordship, kindly recollect, you said 75%. You said there will be negative marking. Only shortlisted candidate will be called for. Now, what you are stating here in the affidavit, with no declaration result of the first phase of OMR MCQ based before the teaching proficiency test, such an approach is based on the motive to promote equity, justice, and transparency of selection process. Very well. If that be the case, you want to maintain it, don't put that 75 marks. Don't put that 75 marks. Why you have put that 75 marks? You have put 75 marks in order to shortlist the candidates. This is totally contrary. Kindly see para 8 now. That with regard to the statement made in of the written, deponent begs to state, OMR MCQ based written test is a competitive test where there exists no qualifying mark. Now, my lord, kindly see that OMR MCQ based written test is a competitive where there exists no qualifying marks. How you will shortlist the candidates? Your lordship will mark it. How do you will shortlist the candidate if there is no qualifying mark? It was notified that all aspiring candidates appearing in OMR MCQ based written will be shortlisted to appear in written teaching proficiency test a level playing with no mark on interview, so that no discrimination is to made to any candidate. Now, my lord will kindly see this paragraph, which I have shown that they are adopting those from those trainings. Now, what they said in paragraph 9, in reply, deponent begs and NITTRs are the Institute for Continuing Education, ITs, so and many other institutions. The NIT conduct numerous courses on fast changing and emergency technology for promotion of excellence in the technical education system and facilitating an in-service teacher to keep pace with the latest technology development. Variety of training courses conducted by Chandigarh is depicted in the calendar. NIT is also impart so and so long term. Describing teaching provisional test as the only subject NITR is false and also aim for misleading the context. Participation in specific number of any short-term training program conducted by NITR and other institutions of continuing education are considered for the purpose of movement to higher grades under the career advancement scheme in case of in-service teachers and other professions, so that teachers once appointed continue updating themselves. So the mandate of so and so is all encompassing for promotion of excellence in a technical and not limited for training on teaching proficiency as submitted by writ petitioner. So, my lord, here what they brought, NITR, syllabus was brought from NITR. I have shown, my lord, that syllabus was brought for those innovative written tests. They have adopted. We are saying you have adopted from them, from that NITR and this NBA, that we brought it. That's why I have shown, my lord. Now, this is what stand they have taken, my lord, in the affidavit, all same stand. Now, my lord will kindly see, there was a writ petition filed earlier in respect of some of the candidates before this honorable court, challenging, my lord, the advertisement, also challenging that they are all 3F candidates. So how their services have been regularized, how their advertisement has been made. So there was a writ petition which was filed. And ultimately kindly see what is the stand taken by the government in that writ petition, my lord. And it's my lord, this is kindly see, my lord, this writ petition. Lordship will kindly see page number 6 and 7. Lordship got it? 6 and 7.
Yes.
On the top. Mr. Gogoi, learner standing a higher education Assam, placed before the court. Selection of the post of assistant professor in the State Engineering College shall be done following the provision of all India. There are two, I told my lord. One is engineering, one is polytechnic. Shall be done following the provision of All India Council for Technical Education measures for maintenance of standard in technical education degree regulation 2019, which is still in force, which I have shown my lord in 2019, and other relevant regulation of the state applicable for those advertised posts. The authorities concerning for filling up of the vacant post of assistant professor in different state engineering college are as advertised on 21/2/2023, which I have shown my lord, that's the advertisement. Decided to follow the recruitment policy having written examination of 75 marks with OMR MCQ based written examination, also teaching proficiency test of 25 marks. During the deliberation of the matter, it is brought to the notice of the court with regard to the office memorandum dated 24/1/2022 of the state government in higher education department that relates to guideline for selection of assistant professor librarian in provincialized government and government model college, where minimum of 2 marks are allotted to a candidate for having teaching library management experience in the concerned subject domain, 1 mark for each completed year of service after acquiring UGC norms in provincialized government affiliated degree college, libraries of government institute, higher secondary college, classes of provincial school, with the observation that the period of teaching experience is less than 1 year, then the marks shall be reduced proportionately, and in that regard, a maximum of 3 months teaching experience will be countable. Therefore, as contended by the petitioner with regard to awarding of 5 marks for each year of teaching experience to a maximum 25 marks toward teaching proficiency test, the court is of the view same cannot be granted by the writ court in exercise of the power conferred under Article 226 of the Constitution as a domain of the concerned employer, higher technical education department of the state, who can only allot and award being accountable in filling up those vacant section posts of assistant professor in state engineering college as advertised on 21/2/2023. My lord, we are not saying that your lordship has to look into it. What you are saying, as my lord, that is a submission that yes, experience, past experience will be counted as per the ASAT regulation, my lord. Court said that the petitioner advanced that 5 marks, 5 for each year. That said, it is not domain under 226. Now kindly see, go ahead, my lord. After hearing the learned counsel parties and considering entire aspect of the matter, the writ petition is disposed of motion stage itself, directing the petitioner to submit a fresh petition stating the grievances and prayer before Secretary of Government, so and so, honor before so and so, along with a certified copy, including the annexure and so and so. Consider such prayer of regarding allotment of, in the event of filing such repetition by the petitioner within the time so specified directive of Secretary of Government of Assam Department of Education shall dispose within a period 30 days from the date of the receipt or not before holding the proficiency test in terms of the state advertised, where whichever is earlier, considering the provision relevant regulation of All India Council Technical Education applicable, as well as relevant recruitment rule for recruitment to the post of assistant professor so and so, as a, if one such consideration authority concerned come to a conclusion candidate entitled for some marks toward the past teaching experience assistant professor of any branch with regard to relevant post while serving, the state authority shall do the needful in accordance with the law. So my submission before your lordship to show that yes, past count services can be given by them. Suppose let them say, my lord, they have rejected the repentation. But even they rejected the repentation, let us say they rejected the repentation. But one has to go by what the act says. AICT regulation is very clear. Past count service has to be taken. So my humble submission before your lordship, that recruitment notice which they have issued, my lord, that should go. Advertise, let the advertisement remain, but they have to come with a fresh recruitment notice with indicating that I am existing lecturer. My past count services will be counted in the recruitment notice. Syllabus.
Recruitment Notice in terms of AICTE.
AICT. Recruitment notice which we is put to challenge before this honorable court. That is, my lord, we'll see at page 66. Page 60, this is a notice at page 66. This is what we are challenging. This should go, my lord, 23/4/2023, because there is also an interim order which is passed by this honorable court. I have read that they should not go ahead with this test, recruitment, teaching skill proficiency test, till it is decided by the court. There is an interim order which has been passed. So I'm not saying, my lord, they can come, but let them come properly, my lord. My past count services, they have to indicate because it's part of AICT regulation. And this particular syllabus of innovative written teaching skill permanent test should go. Whatever minimum, my lord, as a BTech or my lord BE, that whatever we have learned, that syllabus they can give definitely, my lord. So my humble submission before your lordship is that this recruitment notice is not in accordance with the AICT. This syllabus, no one can appear with this syllabus, my lord. That is why some few writ petition has been filed before this court, my lord. They are not agreed by the advertisement. Advertisement, they are very well, they participated. Only they are agreed by this recruitment notice, which they will notify. This they will set aside and notify freshly, my lord, recruitment notice, putting all those what is AICT norms laid down. Rest, my lord, all the same, all this.
One is the Polytechnic,
Yes.
this present one.
Yes.
The other two,
Other two is engineering college is 3048 of 2023. Next. Next is, my lord, 3051 of 2023, that is Polytechnic.
3051.
3051.
This was the Polytechnic.
Yes. The existing employees. So these polytechnics all are engineering one. These are all, my lord, your lordship, kindly note down. All these three writ petitioners, these are all the existing employees.
WBC 3048.
3048 is appointed under 3F. My lord will kindly see that, my lord. 1 second at page 3048. 3048. In 2020, lordship will kindly note down. This is regard to Dhemaji Engineering College. They have been appointed, my lord, on ad hoc under regulation 3F. Lordship got it? At page 40. I'll come to subsequently the advertisement. What is about their case? At page 40, appointment is purely on ad hoc basis for a period of 4 months as per regulation 3F. Lordship got it? 3F. Now, at page 42, yes, 3F. Name of the post indicated. Now, at page 42, these are the selected candidates. On 17th of February 2021, first paragraph, plus our last paragraph, plus as admitted temporary for period of 4 months, only with effect from date of joining. Lordship got it? So appointed on the 3F. As assistant professor, Dhemaji Engineering College under regulation 3F, so and so in the scale of pay, as admissal temporary period of 4 months, only with effect from so and so. Now their extension, they were getting extension from 2021 Yes. Last extension which was granted at page 45. I have not annexed other extension from time to time. Last extension which was granted is 2023. The governor is pleased to extend the service of the following 15 numbers of so and so for another period of 4 months with effect from 22/10 under regulation 3F of Assam Service Public Commission. They are still continuing the service. Now, my lord, at page 46. This regulation has been framed under 309. This is now my lord, earlier, your lordship will note down, earlier all this was conducted by APSC, through APSC. I have been told that this has been challenged before the division bench. How they brought this regulation under 309, Article 309, where a commission under APC under that 1951 commission, that how they brought Article 3, how it was replaced by Article 309. That is before division bench, which they challenged the regulation. So this regulation, they brought it on 23rd of June 2021 under 309. Assam Engineering Service Recruitment Board shall conduct, kindly see my lord, Higher Education Technical Department notification, exercise of power conferred 309. Governor is pleased to make the following regulation in respect of composition staff of Assam Engineering Service Recruitment Board. Now, whenever their selection will take place, it will take place as per this notification. And if your lordship kindly see, there is a selection board. What is the selection board? At page 47, Constitution Assam Engineering Service Recruitment Board. At page 47, 3 my lord, Constitution of Assam Engineering Service Recruitment Board. It is not through an APSC, it is by virtue of this regulation. The board has to become, board was constituted. And kindly see 54. So, page 54, name of the post, kindly see my lord, S5, Assistant Professor, Technical and Non-Technical, 25% of the total sanctioned post. So 25% will be under direct recruitment. Lordship got it? Yes. And kindly down below at serial number 10, lecturer in polytechnics. That is 75% direct recruitment. So these are the mode how recruitment takes place, my lord. Selection takes place. Then page 55, 3F, my lord, ex post facto appointment of those under 3F, my lord. That approval was given by the cabinet. Kindly see, my lord, 1512. In interest of public service and person department notification and cabinet decision, the governor of Assam is pleased to approve the ex post facto appointment of following assistant professor of Dhemaji Engineering College, appointed a regulation 3F of the Assam Public Service Commission limitation function with effect from date of joining on usual pay and allowances as admissible. So these are the ex post facto appointment in respect of 3F, which was not given earlier. Now, thereafter, my lord, we have been working in the department at page 57. That's the advertisement which I have already placed 21/2/2023. Now, my lord, the writ petition was moved before this court, my lord, regarding my 3F. They said it should be regularized. Ex post facto approval was given at page 63. But the court at page 77, kindly see, my lord, at page 77. See at page 77. However, it is made clear that any appointment to the sanctioned vacant post of assistant professor technical in Dhemaji Engineering College to which the petition alleged in this petition on 17/2 they were appointed to those sanctioned posts on ad hoc basis in terms of selection made on the basis of impugned advertisement issued by so and so shall be subject to the outcome of the writ petition. So now thereafter we participated at page 78 in pursuance to the advertisement. We participated at page 78. All different candidates petitioner participated. From 78, the lordship will find at page 87. Few of we have given there 87 from 78 to 87, where they participated in pursuance to the advertisement that has been issued. And at page 88, these are what I have shown, my lord. Schedule of OMR based written tests on different tests, different dates, which already had been shown. One is technical at page 88 and page 89 is non-technical. Now recruitment notice on 23/4/2023, which is impugned. Here at page, this is been put to challenge. Now at page 114, here page will be different. All India Council for Teachers Technical Education, which is 2019, which have annexed in that writ petition also. Here page is 114. Now kindly see 116. 116 is one, that is the assistant professor. Mode of appointment is direct recruitment. Lordship got it? Now, 1-to-1, here's a 1-to-1. 1-to-1 is the counting of past services at 2.25. 2.25. 2.25 F Roman 1. 2.25 F Roman 1. And my lord will see mandatory to put us in. Mandatory. I don't know. So this, my lord, then.
Where that mandatory?
Yes, yes, I have put the mandatory. Yes, I am given. Huh? 123 miles. Clause 4. 123
Yes.
clause 4. Mandatory teacher training. What you got it? 4.0. Now, thereafter, my lord, this is the Gazette notification of 140, page 140 regarding about the Assam Technical Education Service Rule 1981, which I have shown the book, my lord. This is 21st of July 2008. And if your lordship kindly turn to page 141. 3, my lord. 3, 141.3. Amendment of Rule 8. In the principal rule for Rule 8, the following shall be substituted: academic qualification minimum academic qualifying experience of a candidate shall be prescribed by AICT from time adopted by the, which I read, my lord. Yes, I have brought notice to the court by annexing this. Now, my lord, thereafter, I put the order this way. Now. Then, my lord, at page 190, there's an order of the High Court, which I moved the first writ petition, which I argued the first writ petition. At page 191,
Same petitioners?
these are different, but this order will apply to all. This is in respect of earlier writ petition, my lord, which 2286. 2286, which you argued, the first writ, item 10. I have annexed this because it will applicable to the other writ petition also. Now kindly see at page 191. Learned Counsel petition submit that these teaching provisional tests are required to be obtained by candidate only after selection, upon they being put for training in National Institute of Teaching's Technical Teachers Training, and so it is submission of the learned student recruitment process for the post of lecturer, so and so. As such, a question of having skill or proficiency without there being any exposure, either way of a specific training or by a long-term experience, is totally contrary to norms and parameters set by AICT, which are bound to be followed in terms of recruitment to the technical education colleges. Learned submits that subsequent notice 23-4 has expanded the scope of the advertisement in the parameters which was set forth in the early advertisement dated 21/2/2023, being agreed so and so. Appearing for a submitted present written exam have been conducted. Same has been concluded at last 6/5/2020. Result have not been declared as yet. After declaring result, only the selected candidate will call for teaching provisional test. It is further submitted. Process of selection sought to be carried out by the state through the advertisement is in conformity with norms and procedure laid down. Mr. Gogoi and so under the Government of India, it is left to the wish of individual candidate to go acquire skill development, personal recruitment. Government does not put up candidate and send them for further training under any parameter set forth by National Board of Accreditation. It is further submitted, even in respect of National Institute of Technical Teachers Training, Research Kolkata, it is for the individual candidates to apply and go for training to enhance their skill. The government does not, as a matter of course, put up candidate for such training. Upon hearing learned counsel of parties, that matter will require consideration by this court. Now, prayer for interim order will be considered on the next returnable day. The higher education apprise this court declaration of so and so. This matter, till then the authority will not proceed holding of this teaching provisional test. So as on date, by virtue of the court's order, my lord, the provisional test has not been pulled. That's the case, my lord. And what about the next trials also? 3051, that's not polytechnic. Same as 2286, my lord.
That's polytechnic, isn't it?
I'm sorry.
3051 is polytechnic.
3051 is a polytechnic.
Same as the first case.
Same as the first case. What I added here is that how the posts were advertised, how they appeared. This is there, my lord. At page 45. Page 45. The page 45 is 3F. Same, my lord, 2020. 3F. At page 47, these are the selected candidates. Page 45. And at page 51 is there. And page 51 is the working for 4 months under 3F 2021 at page 51. Or you can note it.
Extension.
Extension. Now extension with the last extension, Lordship will find at page 54. 54. Page 57 is the regulation which they have brought it. 23rd of June 2021, which I have shown, my lord. And the schedule at page 65. Schedule at page 65. See serial number 10, my lord. Lecturer in Polytechnic. Page 66. Yes, cabinet decision, my lord, ex facto, ex post facto appointment at page 66, which I have shown, my lord. Page 73 is the advertisement, 21 to 2023. 69 and 73. 69. These are technical. 69. Lordship can mark it. Lecturer technical. Kindly see 69.
Yes.
Lecturer technical. Lordship will kindly see 21 to. Next at page 73. Lecturer non-technical. Page 76 is the writ petition, which they have challenged because they are 3F. The services regularized, but subject to the outcome, will lordship find at page 84, last paragraph. Same order, which I have shown in the other case. At page 84 is the last paragraph. However, so and so, appointed 3F, so and so shall be subject to the outcome of the writ petition. At page 85, lordship kindly see. Similar order was passed by the court. Lordship got it? Yes. The same I have shown. And thereafter, my lord, I appeared for the OMR MCQ base from 86 onward. 86 till up to 106. 107, my lord. Kindly note down from 86 to 107. These are the petitioners who appeared for the OMR MCQ test as per the advertisement from page 86 to 107. Now, thereafter, 108 is the written test date. These are technical. At page 108, 109, 108 and 109. And technical and non-technical, lordship found at page 108, 109. And thereafter, 110 is the impugned recruitment notice which have been put to challenge. And 111 is the 2019 notification.
Basically, same thing. Same.
Same. All are same. These are same. I don't know trouble. Last order I have annexed the High Court's order. So my submission ultimately, my lord, I have shown this contrary stand has been taken by the state. So my submission is that advertisement will remain, but recruitment notice they have to set aside, my lord, and they have to bring with a fresh recruitment notice as per the AICTE regulation. Of course, they can hold the test. Test is not been laid down anywhere by the, they can do it, but it should be within the confinement of the AICTE. They cannot bring something outside. That's my submission before. Lordship. Deeply obvious.
Submit please, your Lordship.
What you have for?
Lordship.
Respondents?
Lordship, I am representing all the respondent, Lordship. Not respondent, ICT is by my sister is representing ICT. They have no role, Lordship. here. Lordship. Lordship, may I kindly take the WPC Lordship 228623 Lordship.
Yeah.
228626. So Lordship, may kindly come to pair made by the petitioner, page 20 Lordship.
Yes.
Lordship. As parish Lordship, for issuance of a writ in the nature of statutory should not be issued, setting aside and quashing the recruitment notice issued under issue number so and so dated 23/4/2023 by the Assam Engineering Service Recruitment Board, clarifying / mentioning the points regarding teaching / skill proficiency test and all Lordship. Then Lordship, nature of mandamus should not be issued, directing the respondent not to proceed further with the recruitment process of the lecturer technical in Polytechnic in Assam under Higher Education Technical Department Assam pursuant to the advertisement dated Lordship 21/1/23 Lordship. Then Lordship, setting aside and quashing the impugning advertisement dated 21/2/2023 as in violation of the ICT Act as well as the Assam Technical Education Act 1981. My lord, may I kindly mark it, Lordship. They are basically saying that Lordship, we are violating the provisions as mandated by the ICT Lordship. As there is a violation, so the notification dated 21/2/2023 should be set aside in quashed, Lordship. This is the pair in the first petition, Lordship. Then my lord, may kindly come to Bagir Fondes. Then Lordship 304823 Lordship. It's in respect of engineering colleges, Lordship.
Oh. Here also prayer portion?
Prayer portion is page 36, Lordship. Page 36, first prayer is Lordship. Writ of statutory shall not be issued by setting aside and quash the impugning recruitment notice dated. Notice long so and so dated Lordship 23/4/2023 issued by the Assam Engineering Recruitment Service Board. That notice is also Lordship in respect of proficiency test. Then Lordship, mandamus should not be issued, directing the responding authorities forthwith recall, cancel, resign, and otherwise forbid the giving effect to the impugning recruitment notice dated Lordship 23/4/2023 in respect of proficiency test, Lordship. And Lordship, next is mandamus shall not be issued, directing the respondent not to proceed further with the recruitment process in Assistant Professor in Engineering College, Assam, initiated pursuant to the advertisement dated 21/2/2023. Then Lordship, another writ petition also in the Polytechnic, Lordship. It's in WBC 3051, Lordship. It is exactly similar line in respect of the WBC number, Lordship 2286, Lordship. The main contention in all the three petitions is the Lordship have to decide the one moot questions, Lordship, whether we have violated the ICT provisions or not, whether the issuance of the notification dated 21/2/2023 beyond the jurisdiction of state or not, Lordship, or within the jurisdiction of the state, Lordship. I will
21/2/2003 is that advertisement, isn't it? Notice,
Lordship.
not a recruitment notice.
That 23/4/2023, Lordship.
Yes.
That is a proficiency test notice, Lordship. whether it is the violation of the ICT notification or not, Lordship, and whether state has the power to Lordship issue such type of notification or not, Lordship. I will confine my argument. I will divide my arguments in 4 parts, Lordship, and I will address the whole issue, Lordship. First part is, my Lord, if my Lord may kindly note it, Lordship. Whether there is any violation of the ICT's notification, Lordship. Whether there is any violation of the ICT's notification. Whether state has diluted the ICT norms or derogation the ICT norms is there. In respect of the advertisement, as well as, Lordship, teaching proficiency test.
Yes.
And number 2 is, Lordship, whether the ICT provides for any mode or procedure for selection of the post, Lordship.
What is it?
Whether ICT provides any mode or procedure for selection of the assistant professor or likewise, Lordship. And whether state can adopt a policy of its own to select the best of the candidates, Lordship.
The state can select.
Lordship, whether state can adopt a policy of its own to select the best of the candidates, Lordship.
Yes.
And Lordship, one of my argument of my senior sir is that, Lordship, we have changed the terms and conditions of the advertisement, Lordship. Now, Lordship has to decide a question, Lordship, whether there is any change or change the rule of game in the midway of the selection, Lordship. And whether we have deviated from the advertisement, Lordship. Otherwise, also, Lordship may frame that particular question, whether we have deviated from the advertisement, Lordship.
Yes.
Only that 4 issues, Lordship, I will address, Lordship. It will cover everything. I will try to satisfy my Lord. And first issue is, Lordship, whether there is any violation of the ICT's notifications or guideline, Lordship, and whether state says derogate or, Lordship, there is any dilution of the ICT's norms or not, Lordship. Now, my Lord may kindly come to Lord.
First question is, have you adopted the AICT?
AICT we had adopted, Lordship. As per our Act, Lordship, as per Section 8, Lordship, Section 8, we have to adopt the Section 8, Lordship, the required qualification which is prescribed by the AICTs, Lordship, we have to follow, Lordship. And it was the latest amendment, Lordship, we have adopted it. Now, Lordship, the AICT's regulations for degree college, it's 2019 AICT regulations, as well as in the diploma also 2019, Lordship. This is the 2 regulations, Lordship. One is in respect of, Lordship, diploma, and another is, Lordship, in respect of degree, Lordship. Both are 2019, Lordship. And that particular notification also annexed in the writ petition also, Lordship. In internal page 24, Lordship, English portion is start in 1, Lordship, in respect of degree, Lordship.
Yes.
My Lord, degree. And, Lordship, in internal page 20 starts from in respect of diploma regulation 2019, Lordship.
Next regulation is lordship in respect of diploma regulation. The writ petitions now we have in respect of 2286 is lordship. Under the 2019 diploma regulation lordship. That diploma regulation is English portion is starts from page 20 lordship. So my lord may kindly come to page 22 of the writ petition lordship.
Gokul, can you complete in half an hour?
Lordship, I will take more than 1 hour lordship.
Then we'll proceed tomorrow.
Lordship.
Tomorrow only, your lordship, till 12:30 I'll be there. My learned friend conclude his argument. I'll just give a reply on Friday.
Then we can continue on Friday then,
Yes,
Lordship,
instead of tomorrow.
yes. Friday, better Friday. At 2 o'clock,
Friday or Thursday?
Friday, my lord. Whichever is convenient, my lord.
Friday at 2 p.m. lordship.
2 p.m. is better.
2 p.m. lordship. At the fixed item at 2 p.m. lordship.
I'll come on Thursday.
But did us, senior council. Assisted by MS.
My lordship, I kept on Friday.
Yeah.
Yeah, Friday at 2 o'clock. I'll be in Kohima, that's why I'm saying that.
Assisted by MS.
Friday at 2 o'clock. 2 o'clock, first of.
Chitra, you are assisting us?
Yes.
No, thank you.
MS.
As Sutia in one of the case and the rest. Still not. HK now.
Higher education.
Higher education technical department lordship.
Higher education technical department. NMS. And Mr. MS. Our Deca, the council appearing on behalf of SCKL. For the AIC. Again, 16.
Lordship. My lord may at to indicate in the
At 2 p.m.
at 2 p.m.
Interim order to ask him.
Oblige, lordship.
Interim order will continue in all this.
Interim order, is it absolute? No. Interim order possibility to continue
Yes.
in all the 3 petitions till the next.
My lord may kept up to regulation the records lordship.
Deeply obliged.
Oblige, lordship.
In hearing.
May I please, your lordship, to kindly fix this matter tomorrow, as the Enquest Council has already left, lordship. He has some personal difficulties.
Tomorrow will be some difficulty.
Day after tomorrow,
I have from Thursday.
Thursday.
On request made on behalf of Mr. R. D. Sharma.
Yes.
17.
Item 17 order, we cancel it.
I'm deeply obliged for accommodating that case.
But Mr. Saikia, you have half an hour.
My lordship has heard the matter the other day, my lord. Though for the interim prayer, entire matter was in fact heard. The issue was, my lord, while the show cause does not, my lord, prescribes the deficiency. Can it be, my lord, the recognition can be withdrawn, my lord? That is the basic, my lord, things, my lord. Well, this institute, my lord, is one of the, my lord, premier institute of, my lord, established, my lord, in the year 1993. It's the only, my lord, the institute in the entire district of Tinsukia, my lord. The initial, my lord, they granted, the recognition granted in 1998. And thereafter, my lord, from time to time, it has been continued and accordingly the institute has been functioning. The whole trouble started from 2019. I'll just
In that case, my lord, I at least maybe may taken up on Thursday, my lord. So that I will also submit, my lord. On Thursday, my lord. I have no objection. Since my lord, it's now 4 p.m. my lord.
Mr. P.G. Saikia, the senior counsel, assistant prime minister.
A.K. Gupta, ma'am.
A.K. Gupta, learned counsel for petitioner, also heard Mr. I. Allah, the understanding counsel, and Mr. Mender on. When do you want?
Thursday next.
As per their convenience, my lord.
Thursday, my lord. 20th, 20. 15th, madam. I'm sorry. So, public.
Uh, 15, there are some few cases. Saikia, 15, there are a number of cases fixed.
15, in that case, my lord, 20th, 20, my lord.
20. Okay, 20.
My lord, 20.
Yeah.
20.
May I please, your lordship? Your lordship, my, due to some personal difficulties, my senior Mr. Anbara has to leave early today. May this matter may be taken. Your lordship, this matter may be taken on Thursday or Friday.
Anybody for petitioner? Yeah, bring on behalf of N. Bora.
Mr. Anbara, for respondent number 6.
None appears.
Your lordship, petitioner was there before, but now he is not here. We have consented him also.
None appears for the petitioner. We list it up to the vacation. List the matter after the summer vacation.
19.
Why is it coming up?
Matter after vacation, the admission column for here, the matter. Department affidavit also required that. Department also has not filed affidavit.
Affidavit is very much required, my lord.
Who, which affidavit?
Yes, elementary, my lord.
You, Sharma.
No, my elementary department is not yet.
Who is appearing for elementary?
Kindly pass over the matter for today, my lord.
You're filing your affidavit or not?
No, my lord, I am not the elementary council, my lord.
Oh, who's the elementary council? Yes, Fukan.
He'll file an affidavit.
You want to file? Heard R. Islam, S. Islam.
Lordship.
Learned counsel for the petitioner. Also heard Mr.
R. Islam.
R. Islam. learned
Correspondent number
counsel
9.
For the respond number 9. Mr. A. Fukan, learned standing counsel. Elementary education is allowed 3 weeks time to file counter.
Matter may be fixed, my lord.
This the matter. It will come up after the summer.
Interim may continue.
Interim order prosecutor to continue.
Obliges.
21.
Please, your lordship. I am appearing for respondent number 6, lordship. This matter has wrongly come for stay matters. Already stay has vacated, lordship. And today I have filed an affidavit in opposition, lordship. So let the matter come after vacation along with the affidavit of
Also, in
respondent.
this matter, respondent number 2 and 3 are also required to file affidavit. They may be directed, lordship.
Who
Director,
is 2 and 3?
respondent number 2 and 3, lordship, director and IX.
Secretary,
Yes, I am.
2 and 3, lordship.
heard Mr.
MK Hussain for petition.
Learned counsel for petitioner. Also heard Mr.
A. Borua for
A.
respondent number
Bonner,
6.
Learned counsel for the respond number 6. Mr. U.
You,
Sharma.
Sharma.
Standing counsel. Secretary education is allowed how much time? 3 weeks time to file contract with this after 3 weeks.
And matter may be listed for admission, Lordship.
Up to 3 weeks in the admission call.
On-
like
22 and 23.
My lord, in this matter, my lord, I am presently serving as the insurance principal of Golaghat Engineering College, my lord. And there are two writ petitions, my lord. In first writ petition, I have challenged the order dated, my lord, 31/3/2022,
31?
31/3/2022 at page 42. Take it. I don't know who won it. At page 42, my lord.
So finish it.
Yes, my lord.
Lordship may fix the matter on any other day admission hearing and Lordship may.
My lord, only difficulty is, my lord, I have not received
We have
salary, my
also
lord,
filed
from
a
1st of
petition.
April last year. Can it be before the vacations, my lord, for admission?
You have supernated.
My lord, I have been promoted under career advancement scheme, my lord, to the grade of professor, my lord. And if I am promoted to that grade, my lord, my age of superannuation extended to 60 to 65 years, my lord. But my lord, I have been promoted, my lord, and my lord will find my order at page 38. Page 38 is the order. 39 is the original copy, my lord. May I read? On recommendation of the Departmental Promotion Committee, 39. no? 39.
Yes.
Promotion Committee meeting held on 30/3/2022, the following associate professor, stage 4 to professor stage 5 from GP 9,000 to GP 10,000 for promotion of teacher technical of state engineering colleges under career advancement scheme as per provision of government so and so dated 17/1/2018 and OM dated 28/3/2022 with effect from the date mentioned against their names. This is my name, my lord, Dr. Satyajit Paul, associate professor, date of eligibility 17/5/2018. With effect from 17/5/2018, I have been promoted under CAS, my lord, from associate professor to professor. Now, my lord, kindly turn to page 29, my lord, for a moment.
Lordship, that was done, Lordship. After he was, that although their proposal was, Lordship, with effect from 17/5/18, Lordship, but that particular notice was issued, or the notification was issued on 5th of April 2022, Lordship. Before that, Lordship, petitioner superannuated, Lordship.
Date of effect,
That
my
is
lord.
not issued, Lordship, we have filed affidavit, my lord may finally hear it.
You file your affidavit?
We have already filed,
In
Lordship.
the second case, my lord, the government.
Second case affidavit is not required, if that
First
case is, that one is decided, then everything will.
In the second one, my lord, where I have been replaced by another ad hoc employee, my lord. In that case, the government has filed affidavit, but in this case, my lord, no affidavit has been filed.
Are you not required to file in the first case?
First case, Lordship, till today, we have not filed it, Lordship.
Well, kindly.
Lordship
page
will give
29
some
for-
time, we'll file affidavit, then it will be easier for the court also. Otherwise, in second case, Lordship, we have filed, Lordship.
Second case is with regard the ad hoc appointment.
Lordship, in charge principal, Lordship.
Here is the, with regard to.
Superannuation.
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 It's necessary. So,
You
Lordship,
will have to file
give some time. Lordship.
But Mr. R.M. Dekal and counsel for the petitions. In both the writ petitions.
Yes,
Correct?
yes, ma'am, in both the repetitions.
Mr. K. Gogoi and the standing council of higher education. Is allowed how much time?
Lordship,
Short time is allowed.
at least 3 weeks, Lordship, 2 weeks or 3 weeks.
3 weeks time to file counter affidavit in WBC 5804 of 2022. List the matter after.
So let us fix that may kindly be given, my lord. I have not been received any salary, my lord, from last April. From
3 weeks
2022.
will be Summer vacation.
Immediately after summer vacation, my lord. But summer vacation paribo niki? Summer vacation agot paribo? Immediately after summer vacation, my lord, after reopening, my lord.
On 21st, Lordship.
Okay, 21st.
21st July, my lord.
Wait, please, your lordship.
Interim may kindly be continued.
Interim order passed earlier to continue.
I'm deeply obliged.
In item number 18, I was in lakhs in court number 7, your lordship.
Hmm.
So my name may be reflected in the court order. M.H. Luskar for the petitioner, your lordship.
Okay.
Lordship has already directed to list the matter after vacation.
Third thing was last question.
Obliged, lordship.